Let's call this meeting to order. Take our seats, please. That means you, Jeremiah. Because you're the only one standing. Ladies and gentlemen, we still have one election bill left because of, we had a mess up yesterday. So we rescheduled it for this morning so people would have a little bit more notice. And I do note that all members are present. We still are missing, with the exception of Senator Boner, who's got conflicting meetings. So I don't think we need to do a roll call. If you are intending to testify, would you please sign in? And let's get started with LSO 26 LSO 42, ballot harvesting prohibitions. Mr. Anderson, would you lead us through this?
Good morning, Mr. Chairman. Josh Anderson, LSO. This is 26 LSO 42. If you'll recall, we did discuss this bill in the August meeting. The committee made some amendments and then forwarded it to this meeting for additional discussion. And I'll note those amendments as we walk through the bill. So, Mr. Chairman, on page 2, provides that new subsection B, no person shall deliver a ballot to the clerk unless the person is the qualified elector who is casting the ballot, the person is the immediate family of the qualified elector, or the person is an employee of a residential care facility authorized to deliver a ballot under subsection C of this section. And then specifies that this subsection shall not apply to ballots that are mailed to the clerk. Subsection C provides that an employee of a residential care facility, including nursing homes, assisted living facilities, adult family homes, and community-based residential facilities, may deliver, and here's where some of the amendments were of the committee last time, absentee ballots on behalf of not more than 5 qualified electors residing in the facility as provided in this subsection. For each absentee ballot delivered on behalf of a qualified elector under this subsection, the employee shall file an affidavit with the county clerk on a form prescribed by the Secretary of State attesting that the employee is authorized to deliver the ballot on behalf of the elector, and not later than 30 days following each election, the county clerk shall transmit, and the committee added, copies of all affidavits received under this subsection to the Secretary of State. Subsection D, if county clerk, county canvassing board member, or other election official becomes aware of a violation of subsection B or C of this section, any ballot that's delivered in violation of subsection B or C shall not be tabulated. If a ballot is improperly delivered to the county clerk in violation of this section, the county clerk, and the committee added, shall attempt to provide notice to the qualified elector that the elector's ballot has not been tabulated. Bottom of page 3 over to page 4 adds this offense as or violation that section as a felony, and then you see the effective date. So that's the bill, Mr. Chairman. I take any questions.
Thank you very much, Mr. Anderson. Any questions for Mr. Anderson from the committee? Any questions? Mr. Anderson, let's go over the felony one more time. 22-9-113B. That would be lines 8 through 14 on page 2.
Correct. And so that would be just a prohibition of delivering a ballot unless you are the elector, the person, or immediate family, or you are authorized to deliver as an employee of a residential care facility under subsection C. So if you're not one of those 3 people, then delivery of the ballot would be.
Is there anything about intent? So if you accidentally take somebody's ballot, are you prone to a 5-year felony here?
So in the introduction language there in subsection A, if it knowingly and willfully committed.
Thank you, sir. Anybody else? Anybody else? Thank you, Mr. Anderson. Who would like to testify on this bill? Mr. Secretary.
Well, thank you, Mr. Chairman. Really appreciate the continued great work of the committee on these basic election integrity updates. And that's what I view this as. 26 LSO 42 is essentially the same as the engrossed version of Representative Johnson's bill from the 2025 legislative session banning ballot harvesting. As a little bit of background, this bill received quite a bit of testimony when it was initially heard in committee. And after a lengthy discussion with many stakeholders, including the county clerks as well as various constituency groups who had the opportunity to weigh in. I think the bill was very well vetted to ensure an end to risks that ballot harvesting poses while giving careful consideration to residential care facilities. Ensuring that an affidavit outlining the requirements also ensures accountability and oversight in this regard. And one of the things that Chairman Case, that you mentioned at the last meeting was to give a little bit of a background on states that have these ballot harvesting bans. So I want to read some of the states that have these: Alabama, Arizona, Connecticut, Iowa, Louisiana, Massachusetts, New Hampshire, New Mexico, North Carolina, Pennsylvania, South Carolina, Tennessee, Wisconsin, Arkansas has a form of it, Florida, Georgia, Indiana, Kentucky, Michigan, Mississippi, Missouri, New Jersey, North Dakota, Ohio, Oklahoma, Texas. And then you start getting the weak sauce states, Idaho, Kansas, Maine, Maryland, that have ones that are pretty weak sauce. California's actually got one that has to do with when it's sent, not when it's turned in. And then our peer states, which I would put in quotes: Alaska, Colorado, Delaware, District of Columbia, Hawaii, Nebraska, Nevada, New York, Oregon, Rhode Island. Those are states that don't have it and have nothing on the books at all. And we have nothing on the books at all. So I think it's really important for us to get this done. I mean, I'll read the Alabama code if I could. After marking the ballot and subscribing the oath herein required, the voter shall seal his or her ballot in the plain envelope, place that plain envelope inside the affidavit envelope, complete the affidavit, have a notary public or two witnesses witness his or her signature to the affidavit, and forward it by United States mail to the absentee election manager or hand it to him or her in person. So they get rid of drop boxes too as well in that really wonderfully crafted paragraph. I will note that our office has reviewed the staff comment beginning on the bottom of page 3 of this bill draft, and would urge that existing language on page 3, line 12 and line 14, we think that's very strong. We appreciate this bill draft and the discussion it received. I do know that there was some feedback we received from the public after the 2025 legislative session. When I talked about this effort, that there should be some sort of limiting principle or cap on allowing an employee of a residential care facility to deliver an absentee ballot on behalf of a registered voter. It's important that we get this balance right. We acknowledge that, but little concern that without a cap that we could have, hundreds of people harvesting, hundreds of harvested ballots by one person. Of course, that's a policy question. I think this cap should, at the very maximum, be 5 ballots. I would like it to be lower. This was effectuated during the last meeting by amending subsection C on page 2, beginning on line 19, specifying that an employee of a residential care facility may deliver an absentee ballot on behalf of no more than 5 qualified electors. This ensures appropriate sideboards to this policy exception to ballot harvesting while maintaining the affidavit structure subject to verification by election officials at the county and state level. This is about preserving the chain of custody, really basic procedural language that we need in the code. I mean, the code is totally silent on handling of ballots after they're filled out, and that's something we really need to beef it up on and get in alignment with other red states that have these basic election integrity measures in place. So this is pretty basic. I agree we need to get the balance right, but we really need to get something on the books that has some teeth.
Okay, thank you, Mr. Secretary. Questions for Mr. Secretary? Any questions? Yes, Representative Webb.
Thank you, Mr. Chairman, and this thought's never crossed my mind until you were talking. The 5 ballots that the person can deliver, is that total or is that per trip?
Ms. Secretary?
Well, Mr. Chairman, looking at the language, it says 5 qualified electors residing in that facility. So that could be beefed up a little bit. I mean, I would say that, for one, it could be across multiple facilities. But we do limit that carve out to residential care facilities and caregivers, immediate family of the qualified elector. So that's a limiting principle in terms of other just individuals out there. So I guess they could go to each residential care facility. That is one issue I think that you're highlighting.
Representative, did you have a follow-up, Representative Webb? No, thank you. Representative Johnson?
Thank you, Chairman Case. We discussed this previously. The intent was to have somebody that intimately knows that person in the care facility, that they're not going from, bed to bed or a different facility, that they know that those persons, they know who the person is and that they are entrusted with that ballot when they take it to the ballot box. So I don't think we want to allow them to go to another facility unless they are intimately aware of their condition. I don't know. Uh-oh, we're getting flagged.
Ms. Secretary, comment on that?
Yeah, Mr. Chairman, I hear what you're saying, and I think that's a little bit of a weakness in the current language. I also would say that any of these carve-outs, I think the individual that is turning in the ballot needs to fill out some sort of affidavit and oath. So as we've already got these 2 carve-outs. I think that could be beefed up a little bit as well, but I think that's one other thing, one of the requests was, what do other states do? When there is a carve out that is narrowly tailored, and we've already got 2 in this bill, that there is sort of an oath and affidavit, at least the red states, that's what they're doing. And some way of tracking it so it's not just somebody coming in and one other thing too, getting back to the mens rea question from the chairman. I mean, I think Mr. Anderson kind of was clear that it was a knowing violation, but prosecutors engage in these mens rea analyses in these prosecutorial decisions all the time. And I think that's clear in the definition of the felony, but also in what happens on a day-to-day basis in our prosecutorial offices around the state.
Thank you. Anything else? Anything else? Thank you, Ms. Secretary.
Thanks.
Did I miss somebody? Oh, so staff comments, Josh?
Mr. Chairman, so just on that question about delivering more than 5 ballots, so it is limited to an employee of a residential care facility delivering on behalf of not more than 5 electors residing in that facility. So I think
It's not someone going to different
I think
facilities.
they would, unless there are employees at multiple facilities, I don't think they could deliver.
Thank you, Josh. And while we got you, this Secretary mentioned the staff comment. Was that in the earlier version?
Yes, Mr. Chairman.
And how was that resolved?
And I'm sorry, what was the staff comment, Mr. Chairman? I can't remember.
I don't know. We don't have the earlier version.
I can pull it up real quick. Mr.
Okay. You can come in on that in a bit. Thank you, Ms. Secretary. Let's hear from the county clerks. Oh, Representative Webb.
Thank you, and this is more of a question for Mr. Anderson. So we're clear then that, okay, let's say that there's 100 people that cast absentee ballots in one care facility. They would have to have 20 different people deliver those. Is that correct?
Mr. Chairman, that's the way I
Go
would.
ahead.
Mr. Chairman, that's the way I would read the language.
Yeah. We're going to talk about that, I think.
Thank you.
Thank you, Ms. Secretary. Let's hear from the county clerks. Welcome, Ms. Langford.
Good morning, Mr. Chairman and committee. I'm Mary Langford, and I have the honor of representing the county clerks of the state of Wyoming. And as you can see, I'm here by myself today. On the first Tuesday of the month, the county clerks are doing one of their other statutory authorities, and they sit with the county commissioners doing county business. So they're all in the courthouse this morning with the commissioners. I have a couple comments. There's been a lot of comment, there's been a lot of discussion on this bill through the last session and this particular piece as well from the previous meeting. But there's still a few things, or just a few little tweaks maybe that we might put in here that would make it better, that we have some concerns about, have some recommendations about. First of all, let's all remember that we have no evidence of ballot harvesting in the state of Wyoming. One of the issues that continued to be discussed during the development of the bill that did pass or whatever is talking about who could deliver these ballots, being an immediate family member or a nursing home worker. There was a lot of discussion about maybe there isn't an immediate family member available for those folks in their nursing home situation. And it could be a trusted friend or someone else. So that's still, is still a possibility that could be out there to be considered. I know in our nursing home at home, we have folks there that have no family.
Your
And
voice is dropping off.
sorry, a little froggy this morning, sir.
You said, I know in our nursing facility at home.
Yes.
I didn't hear
In our
what-
nursing facility at home, we have folks there that have no immediate family in the community. So there would be the option with having someone that is an employee to take care of that, or maybe that could be a trusted friend. That isn't in the statute or in the proposed bill, but could be an option available. The clerks support the limiting of the number of ballots that someone can bring back to the clerk's office. And as a suggestion, since we had that little discussion a few minutes ago, maybe that should be 5 per election, as opposed to 5 for a year or whatever, to put some cap on that.
Lifetime ban.
Yeah, so that might be something to consider by the committee, to put that cap on there. And then I believe that that's really all that we had else to offer for the bill.
Okay. Questions for Ms. Langford? Senator Steinmetz.
Thank you, Mr. Chairman. Just in looking through this, there are people who are being assisted at home. Do you believe anything in this bill covers, for example, they may not have family members taking care of them, but they have in-home nurses and people like that that are helping them? Do you think this bill covers that in any way, them being able to deliver the ballot
Ms.
for
Langford.
them?
Mr. Chairman, Senator Steinmetz, I believe it might be weak in that area. This is pretty specific to nursing home facility. As you suggest, there are folks that have people that are with certain services that provide in-home care. And I don't believe that covers that here.
Thank you.
Mr. Chairman.
Senator Dockstader.
Mr. Chairman, Mary, what might the clerk suggest then that we step out and cover that area better?
Ms. Langford.
Mr. Chairman, Senator Dockstader, yeah.
What
What's-
would you suggest?
What would,
I'm looking, Mr. Chairman, I'm asking for a suggestion.
asking for a suggestion?
Yes, ma'am.
Through the
Maybe
chair, you guys.
Mr. Chairman, Senator Dockstader, I believe probably there should be some verbiage in there that says that it can also extend to folks that are homebound, that are being provided service by
Caregivers.
caregivers.
Okay.
Thank you, Mr. Chairman.
Representative Yang.
Mr. Chairman, thank you. Ms. Langford, I'm still confused on frankly the premise of this bill. So I hear the word harvesting and that sounds scary. I mean, if I'm voting and I take a ballot and I seal it and sign it on the seal and then give it to anyone because I trust them to deliver it to the clerk's office, what am I protecting against by limiting that process?
Ms. Langford.
Mr. Chairman, Representative Yen, ballot harvesting, typically you see it in places where they do a lot of mail ballot voting. And there's one case that I've read about that was in North Carolina where there was a gentleman that made a lifetime business of harvesting ballots. Where a number of ballots are sent to a household, which can happen. A number of ballots are sent, somebody goes and gathers those ballots up. Somebody goes through where you've got mailboxes that sit alongside the road. I know we have them in our community. I'm sure you do where you live. Gather up ballots, they vote them, they forge them, they take them back. They're harvesting ballots.
So that's, I mean,
That's
that's,
Hold it.
harvesting.
Got to go
ballots.
through the chair.
Mr. Chairman.
Go ahead.
Mr. Chairman, my apologies. So, I mean, that person's essentially considered, is committing election fraud regardless of
Right.
whatever this bill is. So it wouldn't be solved by this bill because this bill also doesn't cover mail-in ballots. I guess I'm still misunderstanding why this bill exists if it doesn't protect against any bad process, because all of what you described is already illegal and under our code is election fraud.
Ms. Langford,
Mr. Chairman, you're correct, Representative Yen.
Thank you, Mr. Chairman.
coming around? Anybody down here? Ms. Langford, I see that Ms. Freese has her hand up, and I do have a question about signature verification, but I think I'd asked it of her the last time, so I think I'll go with her. Plus, she's my hometown clerk, you know.
Mr. Chairman, I think that's an excellent idea.
Okay. Can I ask, though, the facility, when you were clerk over in Sublette County, how many people resided in that facility?
Mr. Chairman, probably about 50.
50.
Yeah, and they have, they have like a nursing wing and then they have a assisted living type of a situation. We have just gone to a new facility in the last couple months. And I believe they have a few, it's a little bigger than that now.
Yeah. I'm aware of these facilities around the state of Wyoming, and they're fairly large. One of the biggest is in Cheyenne, I believe. It's the complex at the Point, is that what it's called? And there's a series, there's assisted living, and then there's regular nursing care. There are a lot of people in there. And for the managers of the facility, this must be kind of an enormous thing to think about. How will you get people's ballots if you could only take 5? And I'm guessing there are a couple of hundred people involved in the Point, and I don't know that. It's okay to use a proper name in the committee, but I probably shouldn't. But that's a lot of people. So at 5, and they've got to be different people, and you can only do it once per election, then you just do the math. That's at least 10 people that are going to have to take 5 ballots apiece. And that's kind of a management issue, I think. And now some of them will be picked up by their family, but you may have family in town and say, well, they always had that option. But trying to get your family there at the right time to get your ballot when it is filled out and then have them deliver it when your family is busy, got kids, it's difficult. And I'm not aware of there being any fraud from any of these facilities. Have you ever heard of it in Wyoming?
Mr. Chairman, I have not.
Okay. Representative Johnson.
Thank you, Mr. Chair. That facility you speak about is in my district, and there were about 25 absentee ballots when I visited. That was the total number. What we really want to stress is that if there is a nurse there or somebody that knows that this person is not going to be able to take the ballot in, that they would be qualified and able to deliver that ballot. It's not going to be hundreds. I think you said that.
Do you think
It's
they'd all
probably-
vote, Mr. Representative Johnson?
Pardon?
I'm surprised there's only 25.
That requested absentee ballots.
Did the others go to the polls?
Yes. Or didn't vote. But
So-
it's not and that is probably 250 people total.
I would suspect, though, for people in a nursing home, I can't imagine that a high percentage would go to the polls. So maybe it's a different level of care that we're talking about. Explain that to me.
Thank you, Mr. Chairman. They're stuck in a little small apartment, and if they can get on a bus and go somewhere, they will. And if they're going to go to the polling booth, they're going to go vote. So that is like a field trip, and they love that and they enjoy it.
Okay.
Thank you.
are some incapable of going, taking a higher level of care.
Some are incapable of
Yeah.
going, some just prefer not to go out and, I think that we have to worry about, I would worry more about people that are incapable of casting a valid vote because of their dementia.
But are they
And I don't wanna-
adjudicated?
I'm sorry, what?
According to our Constitution, unless they're adjudicated mentally incompetent, they get the right to vote.
That's right.
And it's as important as a
So-
gun right.
And so if you have dementia, it would be easy for somebody to say, hey, I'll take that down there for you.
I
And
wonder
we
about
want to make sure that
legislators
that
sometimes.
they are qualified and have an affidavit and are doing it for the right reasons, not to influence a vote one way or another. Thank you, Mr. Chair.
Thank you. Thank you very much for that local color importance. Senator Lannon,
So,
microphone, sir.
Mr. Chairman, thank you. So I think you make a very good point. And I'm going to use my dad as an example again. He was at a facility in Du Bois. And if that's limited to 5, somebody's going to have to gather up the 5
And
and go to
drive.
Lander, 75 miles away to deliver those ballots. Well, what if there's 7? You know, I mean, I'm just trying to think out loud to myself here. Why can't we have a little bit of flexibility on this front with regard to our senior citizens? They don't choose to be site-bound. They would love to go to Lander and vote. I mean, it just seems like we're going to force whoever's running that facility, somebody else is going to have to get in the car and go to Lander because we're only allowing 5. Just to make the point.
But I guess they can still be mailed in, right? Let's remember that.
That's true.
That's true. So got to put that in perspective. So did you have any final comments? And then I'm going to get to our other clerk that's present.
Mr. Chairman,
Go
no, I
ahead.
don't. I'm happy to answer any questions that you have, but I would hand off to Clerk Freeze.
Okay, thank you. Clerk Freeze, welcome.
Morning.
Good morning.
Mr. Chairman, Julie Freeze, Fremont County Clerk, speaking for the County Clerks Association. Actually, we were tasked with a job, or I was, and the Secretary of State, and I know Joey caught me later and said, hey, I'll help you with this. And I apologize, we got busy with some other stuff. I did get my survey done from the county clerks. I will tell you right now, about 10 counties mentioned that they mailed them, and 10 counties said that they delivered. I didn't get some counties to respond yet. So there's a variety of ways that we've been doing this. Some clerks felt it was necessary that their own staff was the one who went and picked it up. I don't know if that would be something we could not do in the future, but they felt like with the scrutiny, it was better that we're under, that it's probably better if they went and delivered the ballots and picked them up. A lot of our residents are not capable of getting out. So in the survey, I get a certain amount of nursing homes, which those folks generally aren't going to go somewhere as a rule. Assisted living is another story. They're a little bit more able to get out. And there was some comments here about, I know here in Fremont County, I know we've had some buses come from assisted living. When I say buses, it sounds big, but it's not, like their van, and they would come curbside because they couldn't make it into the courthouse, and we would go out and help them. Some other clerks mentioned the same thing. We're trying to help them any way we can. Are we registering them to vote while this process is going on? We have had clerks work with each one of the nursing homes, and either a notary goes in and they do it like a mail ballot like anybody else, where they would send in a copy of the ID. Some of our elderly do not have IDs, as was mentioned yesterday. And unfortunately, they didn't get registered, and some of them felt and said they feel disenfranchised because we are not able to assist them because they have Medicare or they have their social security number, but they no longer have an ID of record. That's concerning. When I asked about challenges or what other issues, that was a big one from a lot of the counties, that some of our elderly are not able to vote anymore. Some families do help, not a whole bunch of that. So I think one of the things that the takeaway I took from this yesterday in finalizing this was, the same thing that Senator Landon mentioned is, how do you tell Westward Heights and Lander that has 8 ballots to return, whose ballots are you going to return? Or do you have to find another person in the facility? The big thing that I thought about from the last time we met here is we should have an oath from the facility person, the social worker, the recreation director, whoever that is. It generally helps with that. Why are they not just signing an oath that says, I am only delivering these, I have not helped them vote their ballot? I think you can make it fairly strong that if you did find there was abuse, that you could make sure that they could be prosecuted. I think that would go a long way for those folks to either not want to do that and have other methods like mailing them in, or to go ahead and take that, knowing that they're just trying to help the folks. So I think that oath is a super important thing. And I think we talked about last time, there was one bill in the last session that didn't go anywhere, but it was to remove the outside envelope from just being the outside envelope. A lot of people don't like the fact that their signature is out for the world to see, and enclosing it inside of another envelope, where maybe on the outside of that envelope or inside of the envelope, you could have the envelopes changed to say, I've given my authority to Julie Freeze to deliver my ballot. We as clerks, if it's 5, we're going to have some kind of a mechanism to mark down when those 5 come in, so we don't accidentally, Julie knew about it, but Sarah didn't. So we have to make sure that everybody knows in the office which ones have been delivered by who. So that's one more thing we would have to do. And I'd be happy to answer more questions on this, but that was a little bit, was work with the Secretary of State and Joey, I see you there, that we didn't do
So
a better job.
why don't we
But if
use
can
his
do
full name?
something- Pardon me?
I don't think that the people in the internet world know.
Oh, I'm sorry. Joey Coranti was asked me if he could help with this. And like I said, we didn't ever get together with the Secretary of State to do any work on this. So I apologize that we did not get that done. But anything I can answer, or if there's something we can do, if this passes before the session, to help with this, I think we'd be happy to do that as clerks and whoever wanted to work on that.
Okay,
Thank
question for Ms. Freeze, Representative Johnson.
Thank you, Chairman Case. Ms. Freeze, I love the idea that you would send clerks to the nursing home and would take that role. I don't think we can, would you pay for that out of your own pocket? I mean, how would you do that? I'm fascinated. Maybe we can work this into another bill, but that would be a bona fide collector of absentee ballots if we could work that in, but I don't know that we can get it into this bill. But I think it's a fascinating idea that the clerks actually go to these facilities. Thank you.
Clerk Freeze. I will point out that the Clerk Freeze office goes everywhere. And they're on the reservation. They get out. Clerk Freeze.
Mr. Chairman, Representative Johnson. So the only thing I want to caution is that clerks used to go, I know we did, let me speak for myself here. We used to go to the nursing homes and actually assist them in voting. We would bring a Democrat and a Republican with us. That wasn't always the best. There would be days that we're going to be there, but the voter maybe wasn't having a good day. So then they didn't get to vote because that was the only day to be there. Now, if we're just talking about us dropping them off and say, hey, we're dropping these off, give these to your residents. They need to be back by this date. You can either mail them or call us and we'll come get them. I'm seeing in the survey that some of those did do that. How far away some of them would have to go, I'm not sure that would be. I haven't got to talk to the clerks about that. So that might be a little bit more difficult, but I guess in those cases, we could just say, I can't go that far, but if you would like to mail them, that's your best option.
Yeah.
That's my answer
Representative
to that.
Johnson.
Thank you, Chairman Case. Maybe I look for some legal advice. Would the clerks be exempt from the total of 5 ballots that they could carry? Would we have to write something in there to cover that?
Clerk Freeze.
Thank you.
Did you hear
Mr. Chairman, I think that was for the legal, maybe.
I'm not sure. We thought, Josh, Clerk Freeze, anybody?
Mr. Chairman, yeah, I don't think it would be clear the way this bill was written, so
Yeah.
maybe something to
I
consider.
think, I agree with you. Anybody else? Representative Yan?
Mr. Chairman, thank you. Clerk Freeze, I'm curious, let's say, I'm curious on the actual implementation. So let's say someone from a nursing home shows up with 6 ballots, or someone has returned a ballot that is that person's stepmother. Are you duty bound essentially to refer that to the sheriff's office for a felony charge?
County attorney, I think, but yeah. Ms. Clerk Freeze, you've gone down this road.
Mr. Chairman, Representative Yin, so if that is the way it is written in the statute, my question to your first one is, how do I pick? I mean, first of all, how do I pick 5 out of the 6 that they just brought, or do I have to reject them all? So all of these people now are rejected from their ballots being processed, and I have to turn the guy or gal over, or do I send them back and say, try again? That's hard. Not everybody understands election law. I mean, obviously, it's our job as clerks to make it very clear how many they can bring. That doesn't mean people read what we send or post or advertise, but that is a concern. But if the law said I had to turn them in, I have absolutely done that in my lifetime as a clerk. I would have to do that. My concern more is what happens to these people's ballots that we just talked about? Are they lost? I think we'll be sued and we will lose.
That's a happy note. Anybody else? Okay, nobody else. Clerk Freeze, last time we were talking about this bill, do you recall I asked about signature verification?
Yes,
Mr.
Chairman, yes.
And I think that, correct me if I'm wrong, but I basically, it seems like we don't in Wyoming actually really look at that signature that comes back.
Mr. Chairman, that is true. There is no statutory requirement for us to check the signature. So let me explain how they come into our office. So it doesn't matter what method they come into our office. We have a little scanner that scans the barcode that's on that we put on the label so that we know that it's Julie Freese's ballot, for example. When we date stamp them, we look to make sure we have a signature and everything's filled out, and then we bank it is what we call it, and it goes onto the computer. It says Julie Freese's ballot has come in. Now, if I had a previous ballot that I couldn't find and I'd gotten a replacement and now I tried to send both of them in and the first one came in, it would tell me Julie Freese's ballot is already here. You cannot accept this. So that also helps us to make sure we don't get duplicates. The next part of that is that then it goes just directly into the pile per precinct to go to the absentee board to be counted, and it's in a locked container for that purpose. So we aren't looking at the signature. I did have an issue in the general that I'm still trying to work through a little bit. Our board did not count one that was a thumbprint. From the time she registered to vote, and she always voted, but from the time she registered and had a signature, she obviously has no use of her arms for some reason. Or not that way, but I mean, can't sign, let me put it that way. And so she does have the legal ability to use her thumbprint, and they didn't know it, we didn't know it. So, I mean, there's some work we need to do when we see that to make sure that their application was the same way. We should have caught it at the application. So some of that would be good to look at to say, why does this match, a thumbprint on there, or does the signature look wrong? I know we do that, but we are not required to do that. It would take a significant amount of time to do that, but at this current time, we don't have the requirement to do that.
Just following up on this, everybody, let me pursue this part. So when that barcode is stored on a computer, is that signature scanned and stored?
Mr. Chairman, no. So the only thing that's scanned and saved there is your signature. So let me go back to one thing too. If we are to go to signature verification, I think everybody who's registered to vote right now would have to do something in our office to give us a new signature, or we would have to scan their absentee request, which isn't always one that they sign. You can call in and we can reduce it to writing. But our signature, my signature from 1978 does not look like it does today at all. And so we would also probably have to have some signature software that would help us to identify, because they might be able to tell my signature in 1978 and now that there are some similarities to that. I don't know a lot about signature verification. So just some thoughts on that some signatures, and my signature at that time maybe would have been Julie Hansen, not Julie Fries. So, I mean, when I did get married, then I did have that. But if it was way early on before we scanned this stuff in, then I might have whatever was of record is my point there. So we try to get those caught up as much as possible, but just recognize that it might not look the same right now.
So, committee and Ms. Fries, some states are very heavily into the signature verification. And they actually have software that looks at the signatures that comes in, and they rate them. They have a scale, and if a signature is irregular from previous signatures that they have on file, they have a process that's called curing, and it's where bipartisan teams actually sit down and look at the envelope, compare it against past signatures, and they try to verify if the signature is a match. It sometimes involves reaching out to the voter to cure their ballot, because it's better than not having their ballot go in. But it's a very significant part of their security. Now, it was mentioned that a state to the south of us doesn't have a ballot harvesting process. They don't, but they have a very significant signature verification process. And there are teams of people, bipartisan teams, Republicans, Democrats, that work on these to verify signatures that come in along with the electronic software. And it's a national thing. NCSL has a voting elections committee, which I serve on. I think I'm vice chair. And this is a big deal across the country. And so you see more effort about signature verification. So if we got 7 ballots that come in, you can actually verify that it's the person. And we have, nothing we've talked about is about whether that's a legitimate ballot or not. It's just about how many you bring in and how they get there. And so Representative Johnson, I can see your wheels are turning.
Thank you, Chairman Case and Clerk Fries. This thumbprint intrigues me. How do you verify that, or do you? And the reason I'm asking that is, instead of a signature, wouldn't it be simple to have everybody's thumbprint on and not have a signature? That way you would know that there was one person. If it wasn't that person's thumbprint, that would be a felony. That would be voter fraud.
And then maybe we
you
could
would
have a space
absolutely-
for DNA. You could give a blood.
You would absolutely know. It's
Ms.
right or
Fries.
wrong. Thank you.
Mr. Chairman, Representative Johnson, so just to go back to this person, we see it a lot on the reservation. And I know that happens at the bank, that they don't have the ability to sign their name anymore for whatever reason. And they do use that. And that's actually where this came from. And like I said, we don't have a lot of them, but definitely want to make sure that when we are getting our absentee requests in, like this person, I want to scan a new card for her into our system that shows that is her signature. I know it works at the bank. I don't know what the process is. I could talk to the bank and see what they receive to say this is my signature. But I didn't want to not count her ballot because of some, thing that had happened to her. To answer your other question, boy, I don't know. I usually look forward, but I know that's a coming thing. When you're registered to vote, the retina scan and all that stuff, maybe somewhere down in our future, I might not be here. By that time, I might be dead. But that's a possibility, I guess. I've not heard it in any of the states yet, but that doesn't mean it can't happen somewhere else.
Thank you, Ms. Freeze.
Thank you.
Well,
Thank you, Mr. Chairman. I just want to say that this is a rabbit hole that we probably shouldn't go down now, but it's intriguing and we should look at it in the future. Thank you.
thank you. I agree, it's a rabbit hole. Anybody else? Thank you, Ms. Freeze. Thank you very much. Who else would like to testify on this bill? Mr. Carranti.
Thank you, Mr. Chairman. Joey Carranti. I am a member of the Carbon County Canvassing Board. I want to point to something that Clerk Langford said, and she can either confirm or correct. She said that there was no evidence of ballot harvesting. And technically there's not, because it's never been illegal. It's never been regulated by Wyoming. We haven't looked for it. What I believe is there's no evidence in the cases that we know when more than one ballot comes in from one person that it has been a case of or an enhancement of fraud. Maybe she's shaking her head one way or another, but that's where we're at on that. To Representative Yin's point, anything that would happen criminally that would be delivered by ballot harvesting would already have to be a crime. Yes. And I'm thinking either false registration, false voting on behalf of another person, or you stole mail. So you're already facing a felony. This is just talking about a delivery method in a certain quantity where another crime already has to happen if it's a problem. I'm on the county canvassing board. My position is specifically mentioned in this bill. And I'm supposed to know or become aware if the person is an immediate family member of the qualified elector. But this bill doesn't say how. What rights, what powers, what restrictions do I have to say, I saw you come in with 6 ballots and I don't work for the clerk. I'm just on the canvassing board. I happen to be in the office. And I don't know how you're related to this person, but later on it says, I'm not allowed to tabulate the ballots if I assume that this has happened. But what right do I have to actually prove it? All the questions about the 5, more than 5, how many times, who 5. In the bill draft, it's specifically restricted to the employee of the residential care facility. So clerks, family members, anybody else, it doesn't say they can only do 5. And it doesn't say they have to sign anything. If the clerk goes down to the facility, that's the clerk. The law says put it in their hand. I think the clerk can take as many, but in the language, it's only the employee of the care facility who is authorized and restricted to 5. So that might be something that one looked at. And then on page 3, when it talks about what the employee has to do, it says the employee should file an affidavit. Well, I don't know who the employee is. I don't know what his signature is. He doesn't even have to be a registered elector. In fact, the bill doesn't even say he has to prove that he works for the facility. It just says he has to come in with an affidavit and 5 ballots. So again, how are we doing facility confirmation? Why is the voter not required to sign the affidavit saying, yes, I gave this guy my ballot? And then to some points that Clerk Freese made, we have voters that have been registered and voted in every election for the last 40 years. Their signature is 40 years old and their hand is now 40 years older. What are we comparing it to? Again, as canvassing board
And they
member.
don't have an ID.
Well, that's kind of where I'm going. How do I say yes or no? Even if I know the person, okay, you've gotten older, that looks enough, I'm okay. But I can't, and the law is making a requirement that my position has no authority to prove. I love the discussion about the digital signatures, because we all know as we sign things at the bank, our current signature on paper looks different than our digital signature on that screen. The thumbprints, DNA, I'm terrified of. That's a Fourth Amendment issue I don't even want to get into. You're giving the government things that they would need a court order for in order for you to exercise a right. A little scared there, but if we do continue to work on the voter ID and the free ID that's already available, and some work I'm doing with the clerks and YDOT with their mobile services, those free IDs being made available and producible on site not only contain a photograph, an address, an expiration date, but also a copy of a current signature. And on the Wyoming ID, it's never more than 8 years old. So if that could be a direction, instead of going through all of this or only a part of this, I think the committee should take some time next year to think about that. The county canvassing board member is also included in the group that becomes aware of a violation. Again, at what level is it a violation that I can prove, that I can actually stop a ballot from being tabulated? You're asking me to intervene if I have a thought that might be a problem, as opposed to, under these specific circumstances, you have to prove this and you have the right to ask this. I'm not going to stop any of them. I personally don't think ballot harvesting is a problem. I'm worried about my shift workers. I'm worried about my ag guys, my oil and gas guys who send their ballots in a group. And by this, the guy that delivers them now is a felon. So what do they say? Okay, I don't trust the mail either, but you know what? I'm going to avoid the felony and I'm just going to put it in the mail. Also, I don't see anything in here that says the Secretary of State's being granted the authority to make rules. So only what's in the bill is the only thing. On my side, if this comes into the green books, I'm not going to be looking for anything else. There are no what's in the bill is going to be the execution. So other than that, a rare situation like the thumbprint, what do we do with confirmed, judicially confirmed confidential voters, sufferers of domestic violence who have been authorized by a judge to the only person that gets to know who they are is the county clerk, and even then it's limited. Now we're saying in order to get your ballot back, you have to come in person, which they're trying to avoid, or we have to identify you, which we are not allowed to do on the canvassing board side. So I'd have to see this ballot, and I have seen them before in Carbon County, where we have to say, this is a ballot of a not readily identified person by court order. And I have to accept that without knowing the name of the voter. So how do we get that person's ballot without making them come into a public place they don't want to be, a judge's order saying we're not allowed to know their name, but we have to do all this verification. So if we can figure all that out, okay. But again, how are we not investigating and prosecuting the crimes that have to happen already to make ballot harvesting an issue? And with that, Mr. Chairman, I'll stand for any questions.
Thank you, Mr. Correnti. Any questions for Mr. Correnti? Representative Johnson.
Thank you, Chairman Case. Just one question for you. Do you know any sons or fathers or sons or daughters that have more than 5 mothers and fathers? If a son and a daughter are to pick up a ballot from a nursing home and they're limited to 5, I hope they don't have 5 mothers and fathers. Do you get my point? I mean, that would just naturally exclude the 5 in that count. Thank you.
Mr. Chairman, Representative Johnson, I don't know. The other things I don't know is where a immediate family member is restricted to 5, regardless of where they pick up their family member's ballot. That's not in the bill. I do know fathers that have 5 sons or daughters. And what if it's the other way around? What if they are all in an assisted living facility, not a retirement home? They're all less than fully capable some way, and dad's going to bring them in. So I don't know exactly, but I also know that it doesn't matter because I'm not being given authority as a canvassing board member to find out how they're actually related and how do I prove that. So as far as I'm concerned, nobody's related until the legislature gives me a method to prove and the authority to not get sued for proving that immediate family relationship.
Looks like we go back to DNA as far as I'm concerned.
That's your comment, Mr. Chairman.
Anybody else? That was a joke. Anybody else? Thank you, Mr. Correnti. Who's next? Ms. Herman. Is anybody else going to testify on this bill? Please come up. Get ready.
Thank you, Mr. Chairman.
Go ahead.
Committee. My name is Marguerite Herman, here for the League of Women Voters. I was sorry to miss the public comment period yesterday for the funeral. But thank you for the opportunity to comment today. And I'm just going to point to the real weak point in this bill. And actually, Representative Johnson mentioned the rabbit hole, and I would suggest, if you all remember, Doug Chamberlain, one of the favorite things he would say is keep your eye on the rabbit. I would contend there is no rabbit. So we're chasing, trying to corral something that put our arms around to quantify with numbers, something that is really not a problem. But I, just moving on from there, I would say the big problem, which the clerks have spoken to, and Mr. Correnti, is the number, and trying to put a number on something that is basically it's a crime anyway for improperly handling ballots, and the number doesn't make any difference, 1 or 10. Then you just introduce logistical problems to enforcing a bill that isn't necessary in the first place. And I would say that actually the work the legislature did in 2025 to say the family member, a guardian, or an authorized worker at the facility, I think put governors on the system that may be necessary, maybe not, but workable. Once you put the numbers on it, then you're kind of going off into an area that creates a whole lot of other problems that could keep qualified people from voting. And to corral something that doesn't need corralling, you declare some voters as expendable. You know, you keep people, qualified people from the ballot box. And I think that is the greater problem, deficit for election integrity. So I would encourage you that the numbers don't really actually harm this bill, and I would suggest that you take that out of the bill. Thank you.
Thank you very much, Ms. Herman. Questions for Ms. Herman? Any questions? Representative Johnson, you're hitting all of them today. Ms. Herman has a question.
Yeah,
Yes, sir.
He obviously lives in Cheyenne, doesn't have to drive home tonight.
yeah.
Representative Johnson.
Well, I think, do you have a lock on your door? And the reason I ask you that is that the lock keeps the honest people honest. It doesn't stop you from being burglared. So this bill is kind of like the lock on your door. It keeps the honest people honest. There could still be somebody that could go around this and create a felony. So do you have a lock on your door?
Ms. Herman, you got a lock on your door?
Mr. Chairman, I do have a lock on the door, but I don't think that's a germane question. I guess I would say what is germane is that what is illegal with one vote or 10 ballots or 15 ballots, and the number just confuses the issue and creates problems for people who are operating within the law. And so my comments, Mr. Chairman, address the number, the threshold that somehow that's going to make a difference to someone who has bad intent. And that was just my question, my assertion today.
Thank you very much. Who else has a question? Anybody else?
Yeah.
Representative Yen.
Mr. Chairman, thank you. So, Marguerite, Ms. Herman, thank you for being here. It was great to see you yesterday at the service. So thank you for doing that as well. Representative Johnson brought up that there are certain eligible voters that he doesn't think should be able to vote or should vote. Does the League of Women Voters have a position on that?
Ms. Herman.
Mr. Chairman, I just would respond that we advocate for the ability of every eligible person, eligible voter, to have maximum access to a ballot box, to the process and to the physical ballot box, while maintaining a level of security. And that there are some aspects of the bills that are being handled by this committee that I think go overboard on the security piece to the point that various eligible voters, especially I'll mention the drop boxes. That
Point of
are
order,
going-
Chairman.
I
Point of order.
understand.
I'm sorry, that's off topic.
Let's just try to get
I will answer-
everybody
I'm sorry.
stressed out. This is the last meeting.
I'm-
We're short of
I'm-
time already.
And I'm sorry to be, to waste time here, but I would just say that no group of voters, even one or many, are, should be considered expendable to achieve security that is already in place and reasonable.
Thank you, Ms. Herman. Any other questions for Ms. Herman? Any others? Thank you very much, Ms. Herman. Mr. Garrett.
Thank you, Mr. Chairman, members of the committee. Richard Garrett, I'm a resident of Cheyenne. I appreciate your time, and I'll be very brief, and I'll try to avoid being repetitive, but I'm going to invoke my mom again, as I did yesterday. She was in assisted living in Casper for about 3.5 years. That facility had 120 residents, plus or minus, and probably, as I recall, between 15 and 20 full-time employees. The facility was always having difficulty maintaining a full staff during her residence there. And it would be hard to imagine that they could cope easily with the requirements of this bill. And because they could not cope with the requirements of this bill, I think this bill, as I said yesterday, about 48, is in danger of violating our Constitution. That's Section 27, which calls for free and equal elections. I think that we're right to try to minimize defrauding our seniors and our election process. But in doing so, we are also limiting their ability to vote in elections. And their ability is already limited. And why we're imposing further limitations on a separate class of people is unbelievable to me, quite candidly. I appreciate the Secretary of State's work to mitigate and warn people about the dangers of financial fraud. I even just this morning heard a PSA on the radio that the Secretary of State offered up, urging people to call his office if they heard of any evidence of fraud in the financial world. I would appreciate it if he would do the same in terms of elections and specifically in terms of this class of folks. I think that that could potentially be much more effective than this bill to alert all of us to the importance of election integrity in our beautiful state. And finally, I guess I'd only conclude that, is this just the beginning? What about college dorms? What about the VA? What about the Life Resource Center, Mr. Chairman, in your neck of the woods? What about the Pioneer Home? Where's the fiscal note for this bill that will allow those facilities, for example, to cope with its requirements? Mr. Chairman, I think that this is a solution in search of a problem. We've heard that, and I appreciate your consideration this morning. Thank you very much.
Thank you,
I'll
Mr.
stand
Garrett.
for
Questions for Mr. Garrett? Representative Johnson.
Thank you, Mr. Chairman. Actually, this is my point of order. The negative comment that Representative Yen said about me, I would like an apology and let it on the record that I'm not trying to disallow votes in this process. Thank you.
But your point is noted. Thank you. Questions for Mr. Garrett? Sorry, I thought your point of order was about straying from the topic of the last person. I apologize. Any questions for Mr. Garrett? Seeing none. Ms. Soros?
Jenny DeSaro, Equality State Policy Center. I am also a voter and a lifelong resident of Wyoming. I recall as a kid growing up where we would go into a store and my dad would run in, he'd leave the car running and go do errands. Yes, it was not very ecological. However, it was the fact that he felt safe driving, leaving his car going in and talking on to whoever was in the store. He's a very social guy. And that was the culture that I grew up with in Wyoming. I'm not quite sure what is happening in our state where we are suddenly starting to create bills to keep honest people honest. I thought that law was to keep us just and make the world safe, but not from honesty, from people who are fraudulent. The clerks have made a clear note. No evidence of this kind of harvesting and illegal fraudery is happening that this bill would address. They have done an immense job at trying to work with you and bring solutions to a problem that doesn't exist. Bless their hearts. The time that they're spending to work on this committee's bills is absurd. They have a full-time other job, but they are just going above and beyond. This bill seems to be aimed at further disenfranchising voters in Wyoming who want to be honest, who want to do their civic duty, their constitutional right to cast a ballot and deliver it or have their friend deliver it. Thank you for taking my comments. I stand for questions.
Any questions for Ms. DeSaros? Thank you very much. Thank you. Appreciate it. Mr. Miller?
Mr. Chairman, committee members, I stand here today as the chairman of the Wyoming Republican Party. And as such, I represent 212,000 registered Republicans in the state of Wyoming. The Republican Party as a whole has multiple times over the last several years requested that some law be put in place to restrict ballot harvesting. How that law comes into play is on your guys' behalf. I mean, you guys are the ones that decide that through policy. The bill that exists is a start. I personally would like to see it a little broader. And the reason being is that this does happen across the country. We've seen many cases nationwide where this is happening. I get very put out that people come and say, well, it's just not happening here. It's not happening here. Well, it was the testimony earlier was given that we don't know really if it's not happening here because we've never had a law restricting it and we've never measured it. So we don't know if it's happening here. So I'm not going to comment more on that, but I am going to comment on it has had impact in other states. Wyoming is under siege from the national entities that are trying to get into the Wyoming political scene. It is coming here. And the best thing that we can do is have something in place that will keep it from impacting election. Because if it impacts an election and we do something after the fact, that does nothing for us. In fact, if it has an impact and it puts people in place who are not good people of good moral character, they may, once they're in position, do other things. So we need to do what we can to keep our elections secure. We need to do what we can to ensure that we don't give the opportunity for people to do something and then come back later and say, oh, well, yeah, we talked about this for years, but we never thought it would come here. And then it does. I was in Colorado when they, in the military, when they went ahead and instituted their mail-in voting laws. They were atrocious at the beginning. They've refined them over many, many years. Matter of fact, it took my wife 8 years to finally get completely off their rolls down there. They kept sending ballots here to Wyoming, even though we went down, handed them paper, she signed documents. We had the state call them and tell them, hey, she's been registered here for years, leave her alone. That was happening. And it happens all the time. Across the nation, we see it, we see other cases. Just because we don't have the evidence that it's happening here, and it's never happened, well, it may never have happened here, doesn't mean that it's not coming. And if we talk about it for years and do nothing about it, and then it occurs, that's on all of us. I'm open for questions.
Thank you, Mr. Miller. Questions for Mr. Miller? Questions for Mr. Miller? Mr. Miller, I have maybe a little bit. It seems to me that if I request an absentee ballot and I don't receive it, but somebody else intercepts my ballot and votes it, I'm going to be concerned that I didn't receive my ballot. So I'll go to the polls, perhaps. I know that, or I'll request another one. I'll go down to the clerk's office and say, hey, I didn't receive this. And they'll say, well, it was turned back. Your ballot was returned. That's where you find the fraud of this. And that's not happening. That's not happening. So wouldn't there be a situation? Wouldn't that be the way that this would show up? If someone voted your ballot, intercepted it, and you never received it, and then you followed up on that, that's where we know a fraud's occurred. That counters your point, I think, that it's not happening. And yes, you may answer.
Yeah, Mr. Chairman, I will counter that with Sheridan County. In Sheridan County, Wyoming, there were, and it took us a long time to get these voters off the rolls in Sheridan who were registered to 30 North Gould. Everyone here is probably very familiar with what 30 North Gould is.
I do not know.
It's where businesses register across the state for LLCs, and basically they all have to do is register there. And so you got all these supposed individuals who were registered to there, and then there's another one of these businesses in town that people were registering to that as their home location. 30 North Gould, a building that's a business downtown, totally illegal. It took years of myself and other party members scrubbing the rolls to get those removed. And in the last election, there was finally a notice put out to all of the election judges saying, do not accept if someone comes in and they're going to register these locations. Okay. We only found it out because I found them on list where they were sending absentee ballots. So it does happen. It happened in Sheridan.
Wait, were those ballots returned and voted?
I don't know. Because
find out from the clerk.
I couldn't, well, because the clerk wouldn't tell us down the line, because it's not my role to know if they were, it doesn't fall into my purview to know who actually voted. As a matter of fact, the legislature in the last election kind of removed the ability for us to look at that real time. I used to look at it real time all the time, see who was returned and who wasn't returned. That's kind of why we found out that this was happening, because some of those were returned. I don't know if all of them were returned, but I know some were. And that's how we saw 30 North Gold. Another one with 30 North Gold, what's up with this? And we went and figured out what it was. So I know that it has happened in Wyoming that people register to locations that they are not actually living in, which is not legal in the state. And you cannot register a business. You have to be to a residence, not even a PO box.
And
So
you think some of them were voted?
I believe some of them were.
Okay, we're going to find out.
Yeah, that would be great to find out.
Thank you.
But bottom line is there are issues out there that have occurred that complaints were made, something was done because the clerk finally said, nah, nobody can register these locations. But if it were being monitored more closely, maybe we wouldn't have to have a law like this in that particular case. But if ballots are being sent to places that we don't know, they look fine because they're an address or they're an empty lot, we don't know because we don't follow through enough on that. And if people are doing that and they're harvesting ballots that way, we should do something about it.
Any questions for Mr. Miller? Representative Yen.
Mr. Chairman, thank you. So, Mr. Miller, I mean, what you've indicated is that there's fraud that you found and that you found it and you dealt with it. So I guess I need help with figuring out a situation where this bill helps find fraud, because all I see this bill doing is making family members and nurse staff felons. And so I'm curious, what's a situation where this bill would actually stop fraud?
Okay.
Mr. Miller.
I'll give you an example.
Through the chair.
No, Mr. Chairman, apologize for that. Mr. Chairman, Representative Yen, there is another issue that I'm looking into in Sheridan right now. We have an entire building full of it's a building where older folks stay, and it's not necessarily a treatment facility, but it's an entire building with, I don't know how many apartments, 50, 60, maybe 100 apartments in the thing, that we could not find a single person registered to vote in that building. That makes no sense. But I hear all the time that they're down there, that people are voting for it. So we're looking into that one ourselves. I don't know if it's a medical facility or not, but it's just odd. And it may be that they're using a different address, and that's what we're trying to figure out. So I'm just putting it out there because it's another thing that I'm like, I look into these all the time because we're trying to find things to show that if there is fraud, here's where it's happening so that we can have laws put in place to stop it. On this particular bill, as I said, I think it should be broader than it is. Just looking at the medical facilities or the care facilities is a little bit short-sighted, but it's a start. And I think it's up to you all on policy-wise to decide what that means when it comes to numbers, as one of the folks who was testifying talked about, and exactly what penalties are implied by it. Because as has been stated, once it's identified, there are penalties for other things that should be in place. This is kind of a fallback. We found it now, we're going to do this, so we're going to whack you a little bit harder. I don't know if it should be. I think the words at the beginning of the bill that talk about it being willful and intent, the will and intent, I think that removes making people a felon if they didn't do it intentionally. That should have been my short answer.
Thank you very much.
Mr. Chairman, just a note, I don't think that there is any intention language in here, and
It's actually, I looked that up too, Representative Yen. It's
it's in
old language in Part A on page 4.
so they had to have knowingly and willingly committed, willfully committed bringing 6 ballots. So the intention would still be to bring 6 ballots, but it's not necessarily the intention to bring fraud.
Perhaps. I think we'll figure that out someday.
Mr. Chairman, that's the way I read it.
Mr. Miller?
Yeah, Mr. Chairman, that's the way I read it.
Thank you. Anybody else? Questions for Mr. Miller? Thank you very much, Mr. Miller. Ms.
welcome,
Simmons.
Mr. Chairman and members of the committee, I am Gail Simmons with Civics 307 and Why Vote. The mission of Why Vote is that all eligible Wyoming citizens are informed voters in each election. These proposals grow from fear, not facts. We hear claims about fraud that lack data. Instead of solving a real problem, these ideas create new barriers for Wyoming voters. Ballot harvesting is a term that refers to ballot collection. A voter completes and seals an absentee ballot. A trusted person returns it. That is all. Signature checks and chain of custody rules remain the same. County clerks still confirm the ballot belongs to an eligible voter. Documented cases of fraud with ballot collection nationwide exist in exceedingly small numbers. When they occur, existing process checks and law enforcement already address them. Nothing in this proposal strengthens verification. They only limit who can help a voter return a ballot. These limits hit specific voters. Native American voters often do not receive home mail service and must travel long distances. Elderly voters depend on caregivers on a daily basis. The people with disabilities face real physical barriers. Rural voters deal with distance, weather, and slow mail. When you remove lawful help from these voters, some will not vote. Wyoming should focus on safe participation for all eligible voters. Support secure return options in every community. Provide clear rules and education for ballot handling. Keep strong signature checks. These steps protect election integrity without blocking voters who already have more to overcome than most. Every voter deserves a fair chance to take part. Fear does not build trust. Access does. On a separate note, that's the end of my testimony. I would like to state, Mr. Chairman, that I have voter registration files and voter history files from the Secretary of State's office going back to 2016. I am more than willing to complete the research necessary to verify if absentee ballots were returned from those locations previously mentioned.
I'd appreciate that. Thank you. Questions for Ms. Simmons? Questions for Ms. Simmons? And those lists are publicly available, aren't they?
Mr. Chairman,
Explain that.
in order to obtain election voter history files, which is who voted and how, and the election the voter registration files actually requires making a request to the Secretary of State's office and with some restrictions on it and then being provided to us. It is important to note that our voter registration files are in what's the term for data files, that it's an ongoing file, so it doesn't capture snapshots in time. So it is a transactional database, Mr. Chairman. And so in order to see changes over time, it requires that you grab full data
I see.
at a snapshot in time in order to see those changes. So that is why for the last 9 years, I have been obtaining those through the Secretary of State's office as they have been available to the public.
I see. Thank you. Questions for Ms. Simmons? Appreciate any light you could share on the allegations made. Who else would like to testify before the committee? Anybody else? Let's go online.
Mr. Chairman, there's no one online.
No one online. Committee, we've heard testimony. What is your pleasure? I hear mumbling. Speak up. I got it by Johnson. Who's the second down there? Let's go with Brown. All right, discussion. Any proposed amendments? Representative Webb.
Thank you, Mr. Chairman. I would like to propose an amendment that on page 2, line 20, after the word electors, we put per election.
Page 2, line 20, after the word qualified elector, per election.
Correct.
Is there a second for that?
Second.
Got a second by, we'll give it to Weber. Discussion. Discussion. All those in favor signify by saying aye.
Aye.
Opposed, no? Okay, that one's passed. Who else? Senator Landon.
Mr. Chairman, thank you. I would propose an amendment on line 19, page 2. After the word of, strike the remainder of that line, not more than 5. And on line 20, strike the numeral 5, so that that sentence would read absentee ballots on behalf of qualified electors.
Per election now. Yeah.
Per election now.
Is there a second?
Second.
Second by Yen. Discussion. So this would remove the limit entirely, but there's still an employee delivering ballots from residents. Discussion. Any discussion? All those in favor signify by saying aye.
Aye.
Aye. Any opposed?
No.
No.
Looks like that has failed. Anything else on the bill?
Mr. Chairman?
Representative Dockstader.
To line 18, looking at a way to, we take care of the employees, those in residential care facilities, we're taking care of the nursing homes, but what about someone just taking care of an aged person? What about on page 18?
Or line 18?
Line 18, after facilities or assigned caregiver may deliver absentee ballots.
Where would you insert that, sir?
Page 18, after the word facilities,
Community, okay. Or caregiver, that's before the,
assigned caregiver.
yeah, or assigned caregiver. Is there a second? Second by Stein, Metz. Okay, discussion. This takes care of the homebound people. Any discussion? All right,
Mr. Chairman.
let's hear it, Yen.
Yeah, my only discussion is, this is still a felony offense, so how does a caregiver know for sure that they're gonna fall under this statute if it just says caregiver? Do you have to provide proof to the clerk? How does the clerk administer and decide what they should and should not allow?
Anybody have an answer for the gentleman? I think it comes back to the knowing and willfully. I mean, if they're just trying to help the person that they take care of, I don't see how you can go down and get into any felony territory, even if you did it for 8 ballots. I can't see that that is knowing and it has a willful intent. And if you disagree, tell me, please.
Mr. Chairman?
Go ahead, Senator
I don't
Dockstader.
disagree, I agree. And you asked about that in the very beginning, and he noted, our attorney, knowing and willfully.
Mhm. Okay, any further discussion on the amendment? Representative Webb.
Thank you, Mr. Chairman. Do we need to, who is the assigned caregiver? That's is that appointed by somebody? That's a little bit of a broad term. Does that need to be identified or?
Yeah. And is it singular or, I mean, people I'm familiar with homebound, they have several people that come in, not one is necessarily assigned, but is the assignment that the voter is assigning them to take it in? I'm not sure I understand that. But Senator Dockstader?
Mr. Chairman, I think that's.
Got to have a green light.
Yeah, I'm trying.
Getting into Senator Scott territory there for a second.
That's what I was trying to do, is make sure that whoever it was, the assigned caregiver.
Isn't
I'm
that
not giving
signed by the
names.
voter? Is it the voter that assigns this? Like I have 3 caregivers, Mary, Nancy, and Jim. And I'm citing Jim to bring in my ballot. Is that who the assignment is?
Mr. Chairman, if he's assigned that day.
Yeah. Oh, you're assigned to go take care of him.
Right.
Okay. Representative Webb, Representative Johnson, I'm sorry.
Thank you, Mr. Chairman. A little language we have from another committee we were on, Joe and I were on, and if we put bona fide caregiver in there, maybe that would solve the problem.
Take out the word assigned and put bona fide. Josh, you trying to get my attention?
Mr. Chairman, so just make sure I'm clear. So up also in subsection B, it requires a person to be an employee of a residential care facility, so we may need to
conforming
make a
language there.
conforming change there as well.
Yeah.
Mr. Chairman.
It would be, and just throwing something out here, employee of a residential care facility or homebound person or something like that. Representative Brown.
Could we use primary caregiver?
I'm not sure. I think that has meaning in the medical world, but not really when you're doing residential care services. We still have, we don't even have a second on bona fide. Do you want to start back at that? And was that a friendly amendment?
Yes.
Okay, so instead of assigned, we're going to do bona fide if the second agrees. Okay, so at least we got that far. You could take the same language and insert it after person is a, you could say it on line, I'm thinking out loud, line 11, elector or the person is a bona fide caregiver or is an employee of a residential care facility. Thinking on the fly there. Josh, you got that? Would that be friendly to your amendment? How about your second?
Yes.
Okay. Do we got that? We got it in two places now? And it's the concept of a bona fide caregiver. We good? All those in favor signify by saying aye.
Aye.
Aye. Any opposed? Got through that one. Good. Anything else? Anything else on the bill? Representative Yen.
Mr. Chairman, I mean, as I stated during our discussion in the testimony, the bill makes no sense. Just transportation of a ballot shouldn't be a crime. It's not unethical for me to ask my friend to take a ballot to the clerk and give it to them if I trust my friend to do that. I think the hypotheticals that people have been suggesting is, again, already election fraud and is already illegal. The idea that we should criminalize friends and family members or office staff or nursing home staff at any level and risk them being felons feels absurd to me. And so I'll be voting no. Thank you, Mr. Chairman.
Thank you, Representative Yen. Any further discussion? Ready for a roll call?
On the motion to sponsor 26 LSO 42 ballot harvesting prohibition as amended. Senator Boner excused. Senator Dockstetter?
Aye.
Senator Landon?
Aye.
Senator Steinmetz?
Aye.
Representative Brown?
Aye.
Representative Heft?
Aye.
Representative Johnson?
Aye.
Representative Locke?
Aye.
Representative Lucas? Representative Webb?
Aye.
Representative Weber?
Aye.
Representative Yin?
No.
Co-Chairman Knapp?
Aye.
Chairman Case?
No. Thank you, everybody. Why don't we take 15 minutes and we'll come back at 10:15. We'll pick up on the agenda at the 8:30 item.
11.
I guess it's the 9 o'clock item. Ah, I didn't know this. Ladies and gentlemen, we'll come back to order, and we're going to start off with a request by Senator Landon. Senator Landon.
Mr. Chairman, thank you. May I have privilege of the floor?
Absolutely.
Real quickly. Fellow committee members, just a real quick, I know we've got to get back to work. As you know, I've served these past several months. It's been a privilege to serve as chairman of the Capital Exhibit Committee. It's an effort to finish up this beautiful place where we're meeting today. There's some additional work that's been completed over the past recent weeks that I just wanted to commend to you. If you have a minute to go down, if you know where the media hangs out and where the media room is, that hallway has been completed, and that's the hallway where our visitors from all of the schools around Wyoming, that's where they come into the building. And so that was a very important entrance into what we hope will be a really special day for all of them whenever they get here. And just really proud of that effort. Can't say enough about how amazing it has been to work with the staff members provided, colleagues of Josh's on the LSO, and they've been terrific. And we've had ex officio members of that subcommittee who have been there since the beginning. But anyway, the work is nearing an end, and that's a piece that I thought the committee might enjoy taking a look at. So, yeah.
Thank you very much, Senator Landon. We need to commend you on your work and very much appreciate it. And it's kind of a very big moment for Wyoming in that we lost Dick Cheney. And I just found this out myself, and talk about a towering figure in Wyoming's history and recent history. He's addressed both houses of the legislature. I'm very privileged to be there when he did. And the day that he was no longer vice president, his first stop was at the Wyoming legislature. We held a reception, and we all stood in line and shook his hand. And that was a difficult moment for him. He was so brave, and so he led this country in war. He produced a great family, and I would just call for a moment of silence for the Vice President Cheney. Thank you. Our love and respect goes to the Cheney family. Thank you. All right, we're back on track. That's a big deal. I'm sorry. He was always so good to me. Political parties, the 26 LSO 185 political parties, County Central Committee. Mr. Anderson.
Yeah, Mr. Chairman, Josh Anderson, LSO. So 26 LSO 185. So this bill was requested at the August meeting up in Casper. The bill itself is relatively short, and then there's a staff comment attached, rather lengthy. It's not really directly related to that bill request, but I'll get to that as I get to the staff comment. We've had some kind of requests, and even was mentioned several times yesterday about how political parties are treated in the statutes. And so there was some kind of request to begin that discussion of that, and so that's what the staff comment deals with. But since this bill was amending a part of that section, that's why that staff comment is here. So first, the bill, Mr. Chairman, on page 2 just specifies that the county central committee of each political party consists of precinct committeemen and committeewomen elected in the county at the regular biennial primary election and duly elected party officials in accordance with party bylaws. So that was just the change that's being made to the statute. Take any questions on that part at first, and then we can get into the staff comment, Mr. Chairman.
All right, any questions for Mr. Anderson? Any questions for Mr. Anderson? Senator Landon.
So, Mr. Anderson, thank you. I've thought about this one, just, I've often wondered about why some of this is in our statutes to begin with. And just wondered if you had any thoughts about the history and development of us getting into, work that could be reserved just for parties.
Mr. Anderson.
Mr. Chairman, yeah, I mean, I think there is quite a bit of regulation of the parties that's in statute, and that's kind of what the staff comment deals with. As for the reasonings behind that, I don't know if I have an answer for that, Mr. Chairman.
Any other questions? Then I'd let you go through the staff comment. Any other questions? Why don't you do the staff comment so we can wrap it up?
And sure, Mr. Chairman, so the staff comment just says, this bill is amending a section of the statute dealing with political parties. There had been discussions from the committee back at our first meeting and again in Casper about, consideration of removing political parties from Title 22. As I looked into that, and of course, there's numerous references to political parties throughout the title. I think, we would need some additional direction on what that might look like if the committee wanted to look in that direction. If the request was to kind of remove the regulation of political parties, that could potentially be accomplished by amending or repealing 22-4, 101 through 120, and those statutes are copied in this staff comment just for the committee's information. I don't intend to walk through all of those. There are also 22-4, 301 through 307, which deals with minor political parties, and then 22-4, 401 through 406 dealing with provisional political parties. And then if the request was to go beyond that and kind of remove all references to political parties, that would require amending nearly every chapter in Title 22. So that would be a even larger work or lift. And then the balance of the staff comment, Mr. Chairman, is just, as I said, noting those current statutes dealing with major political parties, as well as there are some highlighted things. So if they were removed, we might need some conforming changes to other sections of law. So that's noted in the highlighted language. And again, like, as I said, if we did want to go that direction, I think we need some further direction from the committee. But this was an effort to kind of at least bring that topic to the committee's attention.
Thank you, Mr. Anderson. The questions, Representative Yan.
Mr. Chairman, thank you. Mr. Anderson, when going through Title 22, were there any places where there were any penalties or consequences if a major party or a minor party didn't follow its statute?
Mr. Anderson.
Mr. Chairman, not that I recall. I don't know if I looked specifically at that question. I can certainly dig a little deeper, but it's not ringing a bell to me right now, but I could certainly do a little more digging. Again, I mostly looked primarily at these three chapters dealing with the rules that apply to the political parties.
Thank you, Mr. Anderson. Looking at Representative Webb.
Thank you, Mr. Chairman. Mr. Anderson.
Can you pull that closer? I know
I'll
you're
just
getting
move
it
up
through your
closer
ear.
too,
You probably
yeah.
think you're shouting.
I just said, I'm the one that can't hear, so.
Yeah.
In your research, and this may be more appropriate for Mr. Miller, do other states regulate their political parties? And if so, how many of them? And pros and cons on that. Thank you.
Mr. Anderson, if you can.
Mr. Chairman, excellent question. I did not look at other states. I'd certainly be happy to do that if the committee would like that, but I didn't look at that, Mr. Chairman.
It might be a good idea if we're going to go down the road farther. Senator Steinmetz.
Thank you, Mr. Chairman. Josh, I just wondered in practicality, if this were to be made or somebody was looking to pursue this, what does it mean for the political party? Is there still a primary election? How would it work in practical terms?
Mr. Anderson, if you can.
So, Mr. Chairman, I think there are a lot of different ways you could go with that. So I think, certainly be things you'd want to make sure to address, would there still be a primary or not? I think you could go multiple directions with that. So, again, that's kind of why, part of the staff comment was, I think we would need a little more direction and input probably from the parties and so forth, but really depend on kind of the direction of the committee and where the committee wants to go.
Thank you. Representative Yen.
Mr. Chairman, thank you. So, Mr. Anderson, so maybe you could hypothesize if you're not a historian. So we have certain privileges granted to state party central committees, county central committees they get to nominate replacements. They get to help fill electors. They get to do several things that, have to do with their elections. Do you think that's the reason that we put these rules in place governing parties, so it would be fair, given that they get to do these things that affect who gets elected and who gets chosen?
Mr. Anderson, if you can.
Mr. Chairman, Representative Yen, like I said, I don't know that I know the history, but I think that makes sense that as political parties have become more entwined, as I said, there's some reference to political parties in pretty much every title or every chapter within Title 22. So I think as the political parties have become more entwined with the political process, I think that's likely the reason that these regulations of the parties were also added.
Thank you, Representative Yen. I think lawyers always say that you shouldn't try to make your case with a witness. You can't you can't make Mr. Anderson speculate on those kind of things. We can ask him to, but it's political in nature. You're gonna make that case. It was a great question, though. You're gonna make that case that there's a public interest to having parties regulated. Okay. Anything else from Mr. Anderson? Anything else? Thank you. Anybody else want to testify on this? Mr. Miller? And you might talk about the bill itself, but also if you want to speculate into the realm of the staff comments and parties in general, that's fine.
Yeah, Mr. Chairman, committee members, thank you for allowing me here today. And I intend to do all that. I'll start off with a statement that covers the bill, and then we can roll into some of the questions that were asked, because I do have some of the answers to that. So I'll start just by going through what I have written. And then, if there are questions, you can certainly ask them in the middle as we go through, but I'd prefer to answer the questions at the end so I can get through this and we don't spend the entire day here working on this. So, Mr. Chairman, members of the committee, thank you for the opportunity to present an issue that needs your immediate attention today. This issue is not new, but it has grown in importance over the past several years as elections have become more contentious, more litigious, and where, as we saw in yesterday's hours of testimony, language matters. Up front, I want also to note that this request for action that I've presented, I've given you two documents. One is some changes to this particular, to 0185, and a study that we did. Up front, I want to note that this request is a nonpartisan issue, as the statute in question applies to all major parties. The issue I bring to your attention stems from language in Title 22, specifically paragraph 22-4-10, subsection B. For the audience's convenience and so that you can be certain of the issue I'm describing, I'll read the pertinent portions of this and other paragraphs and its introductory language, then explain the issues that have continuously plagued the courts due to a lack of consistency or clarity with other sections of Title 22. Issues that, in other less contentious times, were read with broader scope than they are today. The paragraph in contention and its lead-in their entirety reads, 22-4-101, application, composition, election, and qualifications of county central committees, certificate of election. Subsection A, this article is applicable only to major political parties. Subsection B, the one that I'm primarily concerned with, and the bill is primarily concerned with. The county central committee of each political party consists of precinct committee men and committee women elected in the county at the regular biennial primary election. That is who the committee, according to this, is composed of. Except, as provided in subsection C of this section, each political party in each precinct shall elect one committee man and one committee woman for each 250 votes or major fraction thereof cast for the party's candidate for representative in Congress in the last general election. But provided that no precinct shall be entitled to less than one precinct committee man and precinct committee woman. Precinct committee men and committee women shall be electors registered in the party and resident in the precinct. If a precinct boundary line is changed for any reason, the county commissioners shall determine the number of precinct committee men and committee women to which the affected precinct is entitled. You will note that this very specific definition of the county central committee provides for only the one exception, paragraph C, which reads, in any general election year in which a new plan of legislative districts is required, the number of precinct committee men and committee women shall be one committee man and one committee woman for each 250 votes or major fraction thereof of voters registered for that party at the time election districts are adopted by the county commissioners as provided in Wyoming Statute 22-7-101. Provided that no precinct shall be entitled to less than one precinct committee man and precinct committee woman. It is important to note that the several complaints that have made it to the courts and threats of complaints going to court all stem from the fact that common sense has left the room when it comes to application of this section to the operational aspects of this definition and implementation in major party activities. I'll explain. In accordance with centuries of precedents and today's standard practice, elected officers of an organization or committee enjoy the benefits that regular members of the organization enjoy, and along with the additional benefits of being elected as the leaders of groups from private organizations to businesses and even within our own legislature. Those duties include participating in meetings, bringing motions, debate, elections, etc., and are typically guided by the bylaws of the organization and procedural guides like Robert's Rules of Order, which the party I lead uses, or Mason's Rules, as our legislature uses, I believe you use, when questions of process arise that are not covered by an organization's bylaws or restricted by statute. These officers are elected in most cases after long campaigns that themselves can become very contentious, which is why we're here today. And several have over the past few election cycles, and two in particular have ended up in court, taking valuable time away from pressing business that the courts should be dealing with, versus addressing cases dealing with internal party organizational issues. In fact, several courts have recently ruled that the courts should not get involved in internal organizational business, as we've seen with the recent sorority case at the University of Wyoming, and as was determined in a case brought against my party that the judge ultimately dismissed after our bylaws were ratified a second time by our convention body. I mentioned earlier that there is a lack of consistency or clarity between sections 22-1-104B and other sections. For the record, those include, but are not limited to, these four very important sections. 22-4-103, County Central Committee vacancies. A vacancy in the County Central Committee shall occur in the case of death, resignation, failure of a qualified candidate to be elected to a precinct committee man or committee woman position, or removal from residence from a precinct. A vacancy shall be filled by the county committee by election of a registered elector resident in the precinct in which the vacancy exists and registered in the party, or as provided by the party bylaws. This section is addressed in our bylaws. And please note that the previous legislature's acknowledgement of the bylaws is being precedent here. 22-4-105. County Central Committee odd year meeting notice, election of chairman, state committee man, and state committee woman. The County Central Committee shall meet at the county seat each odd numbered year at a time and place determined by the county chairman. The county chairman shall publish notice of the meeting in a newspaper of general circulation within the county, not less than 10 days before the meeting. At the meeting, the County Central Committee shall elect the chairman of the County Central Committee, one state committee, state committee man, and one state committee woman, and other offices as provided again by the party bylaws. A state political party may provide its rules for the election of additional state committee men and additional state committee women. Neither the chairman, state committee man, or state committee woman need be members of the County Central Committee. This section also shows the previous legislature's acknowledgement of the bylaws being precedent and specifically states that neither the chairman, state committee man, or state committee woman need be members of the County Central Committee. 22-4-110, composition of State Central Committee. The State Central Committee consists of state committee man and committee women and county chairman elected at the odd numbered year meeting of the County Central Committees and of any other party officials provided by the bylaws of the party. Again, this section shows the previous legislature's acknowledgement of the bylaws being precedent. And 22-4-118, State Convention Powers and Duties, which directs the major political parties to include guidance in major party bylaws per subsection A, Romanet V, which reads, to formulate or change the rules governing the internal organizations of the party, and then goes on to describe several specific items that must, as a minimum, be included in the party's rules. This section recognizes and provides the party direction to make and employ internal party rules. I'll also reiterate that section 22-1-104 subsection B only has the one exception to the question of who makes up the County Central Committee. These 4 paragraphs in statute that I just mentioned, in the minds of those who want to make trouble, consider them to be non-players when it comes to the reality of the situation. The bottom line is that section 22-1-104B lacks clarity in this case and needs to be addressed before the next elections. That said, if you will note, the 2 documents that I provided you for reference, documents that I will expound upon in the next few minutes, are sitting before you, and I'll answer questions after we go through those. The first is a list of the changes, really cleanup items, that we believe are necessary to bring closure to the recent era of litigation to disrupt cases that have been plaguing our courts. The core cleanup item is to add clarity to the definition of what makes up the County Central Committee. In order to resolve the issues noted earlier, the following text must be added to section 22-1-104B on page 2, line 5. Revise the added text to read after the word election, those who have been properly appointed and ratified to fill vacancies, and the duly elected party officers in accordance with party bylaws. This will clarify and clear up those misconceptions that bring complaints that bring complaints, and that those who refuse to acknowledge the other 4 sections I noted that are already rooted in our bylaws. And they have been in practice for decades at this point. It will address the constitutional concerns that are likely to become a major issue in the current Hot Springs case regarding county officer elections, as noted by the judge in that case. And it will settle the dispute regarding the party's ability, an ability that is provided to the party in section 22-4-118 to formulate or change the rules governing the internal organization of the party that a judge in Natrona County, in the Natrona County case, confirmed and upheld. The remaining list of items add clarity to other portions related to the same and clear up terminology by eliminating and replacing terms like rules with bylaws, because we don't have rules that we propagate throughout the parties. They are bylaws. And officials, and replacing the word officials with officers as they are used in today's lexicon. The second document I provided is a quick study that I asked to have done in preparation for this testimony. This study, and it's not complete because I just asked for it at the end of last week and we weren't able to get all the information, still needs to include 3 final counties as the report in front of you states. It is what that report shows is the harm that can occur today to our party's leadership if these changes are not made. In the report, you will see that there are many, many precinct committee women and committee men who were not elected in the previous August primary. If the complaint posed in the Hot Springs case is upheld regarding the language inconsistencies regarding the makeup of the County Central Committee, our statewide party would effectively lose 184 of the 1,122 seats, a 16% decrease in our party's leadership, as participating members and voting members who currently represent at least 33,920 registered voters of Wyoming within our party. It would also impact those who serve as State Central Committee members, reducing our county leadership, who make up the bulk of the State Central Committee, from 69 members to 51. Can you imagine how that would impact the state? The perception that would exist in the public eye that a few troublemakers that have lost their ability to use common sense by tying the various sections of statute that I described together has been the practice for Wyoming in decades. I can certainly envision it, and it would be likely laid at the feet of those who had the ability to correct the issue over the years as the complaints started rolling in. Those people include the leadership of the Republican Party, the Democratic Party, because we are the major parties, and it includes, let's see where I'm at. As we are, and we are taking responsibility for starting that process of resolving the clarity and consistency issues as I bring this to your attention today. You on this committee have the ability to take the next step in clarifying the existing text by making the changes we are recommending that will properly link the relevant sections, as noted, that will resolve this issue for good. As I end my statement, I know that this issue is in good hands, and I expect that the arguments presented regarding these cleanup items are sound, and that you will see them as sound. And they will be taken up at the next legislative session with your blessing. Thank you for your time today. Do you have any questions for me?
Yes, Senator Steinmetz.
Thank you, Mr. Chairman. And Mr. Chairman, so I'm looking at the information you provided to us on 26 LSO 185, and it goes clear to page 10, but we're looking at a bill with only 2 pages. So I'm not sure, the rest is just a staff comment, it's not a part of the bill. So I'm confused.
Yeah, Mr. Chairman, Senator Steinmetz, the rest of what is in there is recommended changes that we'd like to see beyond what is currently in the bill right now. I'd like to go ahead and have those added as changes as well. To changing the rules, to bylaws and all that.
Okay, sorry, I had to step out. I
Does that make
apologize.
sense?
Senator Steinmetz, keep at it.
Thank you, Mr. Chairman. So this is our last committee meeting and we were looking at a bill with a very small change. So do you think it might be acceptable this time to add the additional language onto page 2, line 5, and look at these further revisions in a non-budget session?
Mr. Miller?
Mr. Chairman, Representative Steinmetz, that's actually kind of the reason that I've that I put these together this way, because I thought that might end up being the point. It'd be nice to go ahead and clear up a lot of issues in that section at one time. For example, the changing the rules to the bylaws and the officials to officers. They are very minor changes. It looks daunting because it's almost a page, but over half the page is simply changing rules to bylaws and officers, and then adding in a couple other places, or in accordance with party bylaws. Each of the lines that say, or in accordance with party bylaws, would probably be needed to be done at the same time. The rest of it, I think, could certainly wait, because that is cleanup. Those are cleanup items.
Anybody else? Representative Yan.
Mr. Chairman, so it seems that a lot of the conflict happens to be over filling vacancies, essentially. I think it's hard on the Democrat side as well to fill vacancies. There's just a lot of them because there's a lot of precinct positions that are defined in statute. Do you think, maybe could the answer be just reducing the number of those precinct committee people that fill the central committee? So, because it seems like the tension is over who ends up being in power to define who are those vacant precinct committee positions. So if we had less vacant positions, there wouldn't be this power struggle on who gets to be at the top to fill those vacant positions.
Mr. Miller.
Mr. Chairman, Representative Yin, that's a very good question. And yes, the Democratic Party does have an issue with filling seats just because of the size. As I noted yesterday, 77.2% of the electorate in the state of Wyoming is registered as Republican. We have a lot more people to choose from. We have a lot more people to represent. The Democratic, in order for it to be fair and equitable across the major parties, the rules need to be the same. So the number of seats are effectively the same. The number of people that are represented is certainly smaller. In a way, because of the smaller number of folks in the Democratic Party, the representation per individual is probably really higher than 200, one pair per 250. And because there are probably a lot of precincts that have fewer than 250 voters in it. When it comes down to it, I don't think that we should reduce the numbers. I'll give you this for the reasoning. We are imparted with some of the things that were talked about earlier. We are given the opportunity as a party to fill vacancies. And we fill those vacancies by going to using the precinct committeemen and committee women. And the precinct committeemen and committee women, in all cases, select 3 individuals, and those 3 individuals are then provided to either the county commissioners or the governor to actually make the choice. That is a much more democratic means than it would be for people just to apply to the county commission or apply to the governor for the position. Because you have, in Sheridan County, I'll use that as an example, we had 106 precinct committee people, not currently, because I'm not the chair now, so I think it's 80 now. But we had 106 the last time that we did a vacancy fill in Sheridan. And those 106 members represented the 12,000 registered Republicans in the county. They were selected by those Republicans in the county to represent them in a form of government that matches the U.S. Constitution. Article 4, Section 4 guarantees each state the right to a Republican, small r, form of government. Because we have that responsibility, it makes sense to have a larger representation to fill that role. We also fill that role in a time frame that goes way beyond the time frame that it would take to do a special election. The major parties are able to go ahead and fill these vacancies, actually all the parties are able to fill these vacancies because the vacancy parts are in Title 18 and other places as well, not just in Title 22. They're able to fill those vacancies within 30 days because we're required, the party are required to come up with 3 names in 15 days. And then the county commissions, I think, get 15 as well. In some cases, they're 20 days on the backside. You can't do a special election in that time frame. So reducing the number reduces the ability for the public to have more representation in who they are replacing in a position that, I might add, the party and the candidate with that party's affiliation behind their name won in an election prior to the seat becoming vacant. They spent a lot of time, energy, and money to get those individuals in that seat. The state of Wyoming and most states recognize that and allow the parties to suggest who would fill that seat. In Wyoming, we go the one step farther by giving 3 names to be selected, of course, selected by an elected official rather than by the committee themselves. The time frame and the energy that is put into those vacancy fills. I'm going to describe 2 of them to you. The one in Sheridan that we did with the 106 of us replacing county commissioner. That one we had 11 candidates. We skinnied those 11 candidates down to 3. 2 of those candidates, right off the bat in working with the county clerk's office, we discovered were not even eligible. So we took those out. We had 9 candidates left. Each of those candidates submitted a package. We had to come up with a facility. We had to come up with the rules. We had to have a special meeting in order to put the rules together so that we could go ahead and hold the actual interviews and do the election process to come up with the 3 names. In the end, it cost the local party in actual dollars, and if you just use $15 an hour, what you pay the election judges, and some of them get paid more than that, over 12 grand over a 15-day period to put that together. It would have cost about $60,000 to do a special election. So if you reduce the numbers, it does 2 things. One, it reduces the number of people who can actually resolve the issue that we've been assigned by the legislature to help fill these vacancies. And it reduces the representation of the party that effectively owned that seat from the last election. That's a long answer probably to your question.
Seems kind of long.
Mr. Chairman, just a quick follow-up.
Representative Young.
Yeah, so I mean, I guess I'm misunderstanding because if the precinct committee spot is vacant, then it's being filled by someone that isn't essentially a representative from that precinct, right? So you're not getting representation from that precinct if we have all of these open precinct positions open all the time. They're being chosen by leadership of the party, which is being chosen by other precincts in the county. So I don't understand why having all of these open precinct positions and then thinning them out a little bit so you have less open positions hurts representation.
So, Mr. Chairman, Representative Yin. Okay, so the way the system works, there are no elections of individuals by precincts individually, other than the vacancy fills. Okay, the precincts make up districts. The districts is where the votes all occur. If we remove precinct committee people, there are fewer people who represent that district. The precincts, yes, they represent the precinct themselves, but combined, they represent the district. So on a state vacancy fill, we fill the treasurer, we fill the Secretary of State seat, all of things which have happened fairly recently. Superintendents, we've done that as well. Those are filled at the state party level. And there are only 3 representatives that have a piece of that from each county. At the county level or the state legislator level, the actual district is what you're filling the seat for. And the district in county commissioners' cases, sometimes they're a county, they're split up across the county, but most of the time it's countywide, so it ends up becoming the whole district. So every precinct has a role to play in those elections, in the selection of those individuals. In the case, the second one that I was going to describe, and I decided not to, but it's appropriate now, was the Senate District 6 vacancy that just occurred. That actually occurred over 2 different counties, multiple precincts across 2 different counties. That was accomplished by the Republican Party. We did it in 15 days. We got 3 names, and then we got the 3 names to the county commissioners, and there were 8 county commissioners involved in that. The 8 county commissioners ended up selecting an individual from the 3 names that were selected between 2 counties. If you had done special elections in both of those counties, it would have taken way more time, and we could have ended up having other issues down the line. The reason that the whole vacancy, and someone was asking earlier, why do we have the parties involved in the political world? Well, we do select electors. We do the vacancy fills. And another big thing is we provide manpower for the elections and as election judges. Those are huge responsibilities that are heaped upon us. A lot of the precinct committee people end up volunteering to be election judges. A lot of them end up volunteering to be poll watchers. In Sheridan County, we have the luxury that probably got 300 to 400 people who volunteer every time. And there's too many to actually do those positions. Other counties don't have that. So the larger your pool of precinct committee people, which I think what we have is the right minimum, one for each precinct, is a good number. It allows the parties to have representation that extends to more than just a couple of large precincts in a county. Does that answer your question?
So I'm really worried about the time today.
Sure.
And I mean, essentially, are we going to broaden this bill or not? I don't see that we have any horsepower to really broaden it. I think we probably ought to stay right to the basis of the bill. If we want to do more work in the interim, that's on the table. So there's a lot at play here. This is a huge topic. And I just want to caution everybody, and you too, Mr. Miller, I think I would be most comfortable if we just stuck to the bill that's been properly noticed to the people, and broadening that would be something for a future time.
Mr. Chairman, if I may.
Mr. Miller.
If that is the case, then I would like to add it, as I stated in my statement, that entire line adding the vacancy, properly filled vacancies line, because without that, those 184 individuals will not be allowed to be part of the central committees. Beyond that, the rest of it can wait for later.
Okay.
Those two pieces are what tie the rest of it together, and it's the way, not only has it been done for a long time, it's the accepted way across the nation when you look at it, and it's the accepted way across businesses, having the officers be a part of the organization and being able to act the same way. Believe me, there's a list, this long of things that if we are going to restrict it, we should probably look at. The question earlier was, do other states do this? I recently went to a Republican Party training session. And in that training session, being new, I didn't know you're not supposed to stand up and not say what the problems are in your home state. So I did. I stood up and said, hey, here's some restrictions that we have. And several other states said, yeah, I got that one, but I don't have all of those together. I don't have this one, but I don't have all those together. Wyoming is way more restrictive than 46 other states. There are still 4 states out there that have not complied with some of the US Supreme Court statutes or decisions that were made years ago. Wyoming is one of them.
Remember, we're staying on the bill,
Yes, sir.
okay? Yeah.
But you'd ask the question. There's someone had asked the question, sir.
I'm trying to stay on the bill. All right. Barring a movement by the committee to really broaden this bill, which I think would be kind of outside of the notice that we gave to the public, let's stick to the bill. So questions about the bill and kind of narrowly define.
Mr. Chairman,
Representative Weber.
I would like to offer the amendment that,
We have to have public
Sorry.
testimony. We're not even close. Okay. Anybody else? Any other questions for Mr. Miller? Thank you, Mr. Miller. Let's move on.
Thank you, sir.
Mr. Correnti. Let's fill out the chairs.
Mr. Chairman, Joey Correnti. I'm testifying now as the Vice Chairman of the Carbon County Republican Party and Chairman Emeritus of the same organization. Looking at the bill itself, as much as I love the precedent of being able to amend a staff comment, I'll just do that in the future and not do it here. Answering Representative Yen's question, is there any penalty for a party officer or member of a political party in Title 22? And the answer is yes. 22-26-120, a violation of election code when specific penalty not imposed, blanket for everybody. 119 above that is specifically violation of the election code by officials, which makes it a felony. And it just says any official deputy assistant who commits a violation of the election code is guilty of a felony. And I think that language is important to contemplate because in the draft, on page 2, line 5, it states duly elected party officials. So in Title 22, we're recognizing these people as officials. And down here under penalties, it says you could be guilty of a felony if you're an official. It's the language. That language also appears in the amendment provided by the Republican Party, which also includes language, those who have been properly appointed and ratified to fill vacancies. I get why it's there. That's actually language from the Wyoming State GOP bylaws. I know, I wrote that bylaw. But because the rest of the language proposed says, in accordance with the party bylaws, for the Republican Party, that will already be captured and allowed by any adoption of the language that's being proposed. I don't know if that language exists in the Democrat Party bylaws. I don't know if they want that. I don't know if they have something else that will be captured by just the language of by the party bylaws that they would have to change if we inserted that language. I do have a amendment to propose in the same exact spot that everybody else is working, striking the and duly elected party officials in accordance with party bylaws on line 5 and 6, and instead inserting and any other party officials provided by the bylaws of the party who have been certified and recorded by the Secretary of State as per Wyoming Statute 22-4-120. And I'll provide that to LSO if you guys actually want to take it up. The reason I use that language is in 22-4-110, composition of state central committee meeting or state central committees, that language exists. And of any other party officials provided by the bylaws of the party. So this is just conforming language that does the same thing as the bill draft from existing language. And I would request if you don't want to make that change, that the change that is made also affects this other statute. So we have the same language in the two places where it's going to appear. The reference to requesting that these are the individuals that have been certified and recorded by the Secretary of State in 22-4-120, 22-4-120 is certification of the presidential elector nominees and party officers. And this is already existing in statute, and it says the parties, by their bylaws, can elect and identify anyone they want, as long as it's already in line with statute. But once they do, they have to send that list of names to the Secretary of State. So in the future, if anybody's complaining who can vote, who can't vote, if they're not on the registered certification list with the Secretary of State, which is already required by statute, then the question is moot until we do other work in Title 22. And before I jump into other work or staff comment, I'll pause and see if there's any question on my addressing the bill with an amendment, Mr. Chairman.
Thank you, Mr. Correnti. Questions for Mr. Correnti? Questions?
Mr. Chairman.
Representative Weber.
Thank you, Mr. Chairman. Thank you, Joey Correnti. Would you please repeat your wording, your proposed change?
Yes.
To 20, you're taking it from 22-4-120?
Starting on page 2, line 5, the word and, strike through line 6, bylaws.
Take out all the new language except
all the new language. And add the language and of any other party officials provided by the bylaws of the party who have been certified and recorded by the Secretary of State as per Wyoming Statute 22-4-120.
Anybody else? Questions for Mr. Correnti? A simple question, perhaps, Mr. Correnti. In 22-4-120, where the certification is made, is it certified that they are members of the Central Committee? Or is it just certified that they are party officials?
The county party officers is what is specifically stated there.
Uh-huh.
Now, with the other change that we're talking about in the actual draft, as
Right.
per party bylaws, the party gets to decide who those officers are. It doesn't say, we might think officers just mean chair, vice chair, committee man, committee woman. Well, maybe it's a secretary. Maybe it's a treasurer.
Maybe it's a
Some
double
counties
down
have
secretary.
Some counties have rather expansive executive committees that include Senate district representatives. Are those of the, well, you know what? The parties can probably decide on their own if those are officers, if they should vote under the authority of this new language. And they can prove that they believe that by certifying it with the Secretary of State in accordance with state law.
But does that certification in 22-4-120 make them members of the central committee and eligible to vote on the central committee things?
The only thing that would make them an individual members of the central committee is being
This statute.
this statute.
Gotcha.
Their election. And then as far as filling vacancies goes, that process is already laid out in statute. The only restrictions on anybody becoming or voting as a precinct committee person is they can't vote on vacancies or officer elections if they're there in their first 30 days, unless it's the first meeting of the year of the new term.
Right.
And if they're appointed, the ratified is our language. If they're appointed properly by statute, they can't vote at the meeting in which they're appointed. That's all statute restricts. So once the central committee follows that process, then they're members of the central committee. This language allows whoever officers are to be voting members of the central committee.
And can I ask you more of a background question, and it follows up, and I was out of the room during part of the discussion, I apologize for that. Do those appointed members of the precincts have to reside in the precincts? And I take it from the discussion that I came in on, no. Did I get that right, or
Precinct committee members, Mr. Chairman, precinct committee members by statute must reside in their precinct,
even the appointed ones?
even especially the appointed ones.
Okay,
Because they're being appointed.
that's what I thought
people that
before
aren't
this
in their
meeting
precinct
began, but
most
I
of the
caught
time.
the tail end of a discussion.
Officers can be from anywhere in the subdivision, the county,
Yeah,
and don't have to be precinct people to be
understand.
officers.
Perfectly clear. Any other questions for Mr. Correnti? Okay, you wanted to finish up on
Just
your,
real quick, you have been provided in the meeting materials under item 3-09.
a treatise.
A framework to start talking about that conversation way later, next year.
Yeah,
It's an approach to the conversation that got started and then kind of shuffled. And instead of removing political parties from Title 22 or throughout statute, it's the approach of Article 1, Section 3, political equality. And it removes, tentatively, it starts the conversation about removing all of the major political party requirements and creates a recognized any political party that's been established follows the 6 requirements of minor political parties. That takes a lot away from some people. That puts a lot of things on the table, but there's deleting everything across statute. And then there's a repealer, and then there's a lot of conversation in the middle. So I just gave that to y'all as a thing to peruse, when all your free time between now and session. And maybe start that conversation in the interim of 2026, leaving it wide open. I worked it for years. I updated it for years. Nobody wanted to have the conversation. So the version you have right now is off the 2022 version of Title 22. I will update it again after we figure all this 2026 stuff out, and I'll get that back to the committee.
any questions for Mr. Correnti? You did all that work yourself?
For years, yes, Mr. Chairman.
Wow, that's impressive. It's amazing. Thank you. Thank you, Mr. Correnti. See no more questions? Ms. Simmons?
Chairman Case and members of the committee, Gail Simmons of Civics 307 and Y Vote. I was also previously an elected precinct woman in Sheridan County. I'm here to oppose the proposed change in House Bill 26 LSO 0185. My concern is that the bill changes one requirement in isolation while the rest of Title 22 remains untouched. Wyoming voters deserve consistency and accountability in the public election processes. State law makes clear who votes in county party leadership elections. Precinct committeemen and committeewomen who appear on the primary ballot represent voters at the county level. They earn that authority by winning the support of the voters they serve. State GOP bylaws within the last few years expanded voting eligibility beyond what statute allows for those officer elections. Unelected individuals were permitted to vote in county central committee leadership elections. This puts a party rule above state law. When a political party uses the public election system to choose public officials, the party is required to follow the law. 2 counties faced court action after internal disputes over who was allowed to vote. The issue in both Uinta and Hot Springs counties were the same. Bylaws granted voting power to individuals who did not hold precinct seats elected through the primary. The courts found these practices violated Title 22. Changing that statute now would not affect either the outcome of the Uinta case, which went to the Wyoming Supreme Court, or the Hot Springs case currently in progress. The Wyoming Republican Party leadership claims to operate a grassroots organization. Grassroots has a simple meaning: bottom up. Local voters choose their representatives. Authority stays close to the people, and in practice, decisions are being concentrated at higher levels of the party. Rules have reduced participation in several counties, allowing unelected insiders to vote in leadership elections undermines grassroots accountability. Wyoming regulates political parties because they use tax-funded elections to nominate public officials. With public benefits come public obligations. The state has a duty to protect voters and ensure fair processes. Oversight does not interfere with political viewpoints. Oversight protects the legitimacy of nomination and the trust of voters. If the legislature wants to reconsider state involvement in the internal structure of political parties, that requires a full review of Title 22. This bill removes one restriction, but leaves all the privileges in place. That creates imbalance and confusion. A piecemeal approach guarantees more conflict in the future. Wyoming voters expect that those who lead their political parties earned their place on the ballot. This is a foundational part of accountability. This proposed change is premature and incomplete. It does not reflect a full plan for the responsibilities and benefits that come with the public election system. And I stand for questions.
Thank you, Ms. Simmons. Questions for Ms. Simmons? Any questions? Thank you very much. Who else would like to testify on this bill? Anybody else in the room? How about online?
Mr. Chairman, we have Vincent Venata online.
Go ahead, Mr. Veneta.
Mr. Chairman,
Go ahead.
Mr. Chairman, sorry, I was muted. Good morning, Mr. Chairman. Good morning, members of the committee. My name is Vince Venata, and I am currently chairman of the Park County Republican Party. I'm also on the state executive committee for the for the Wyoming Republican Party, and I am involved in a number of committees. One committee that I am often involved in is every 2 years with the state convention is the bylaws committee. And as the previous speaker brings up, there are things that are in our bylaws that are not addressed in state statute, because the state statutes on certain issues are vague or do not address them. And so we have to essentially fill in the gaps. And Mr. Corianti spoke earlier, and he's also been very involved in the bylaws for a number of years. And he's brought up a number of things over the years that are not addressed in state statute. And we've tried to remedy those issues through our bylaws because of confusion. But one thing we have noticed in the past number of years is the political lawfare that's being used by exploiting current language in statute.
I echo what Chairman Miller brings up regarding some of the issues we have. And I also recognize the chair here mentioning about Title 22 and what Senator Landon mentioned about Title 22 earlier. That's not something to be addressed this year as a whole. We're going into a budget session, way too complicated, way too short a period of time. I think Title 22 as a whole needs to be addressed in a future legislative session. However, I believe that there are some quick, simple fixes. I believe in KISS. Let's keep it simple, not stupid. So what I would recommend to the committee is a simple fix on page 2 of this LSO draft for line 5 under 224101, subsection B, once again, line 5, and adding where it says elected in the county at the regular biennial primary election, those who have been properly appointed and ratified to fill vacancies and the duly elected party officers in accordance with party bylaws. What does that do? We have individuals throughout the state who have exploited this statute as written and stating that you're not an elected precinct committee man or committee woman, and you cannot vote in elections. Well, that's never an issue until it becomes time to vote for officers in the organization. And where we have a problem with that is in Wyoming statute 224-105 is when we talk about the term of offices for our chairman, state committee man, committee woman, and who else is not mentioned? Treasurer and secretary, and their terms of office. In statute, it says that they're elected in March of the odd year. Well, their term goes March to March. And what individuals have tried to exploit is that they're not a precinct committee man or woman, but they were duly elected in March, 3 months after new precinct committee people have taken their seats. And they're members of the central committee. So essentially, it's been okay for these people to vote for 21 months out of a 24-month term of office. But when we come into that last 3 months, all of a sudden we have people stating, hey, you're no longer a precinct committee man or a committee woman, or your term has expired. So there's just a couple of fixes here that need to be done. The first one is, as I mentioned, on line 5, making it properly appointed and ratified, because there are people who are properly appointed to fill vacancies, and duly elected party officers, the chairman, the state committee man, committee woman, treasurer, and the secretary. Those people can be elected to office, and in state statutes, it says that any person in that major party can run for office. You don't have to be a precinct committee person to to be elected to be a party officer. So that's that one. The next one that I had addressed was 224105. The title states County Central Committee Odd Year Meeting, Notice, Election of Chairman, State Committee Man, and Committee Woman. I would recommend to the committee to strike chairman, state committee man, and committee woman, and just put officers in there. Because the state GOP in their bylaws specifies who an officer is in the county parties, who an officer is in the state central committee. So by removing chairman, state committee man, and committee woman, it makes it simple, whoever the officers are. And then adding at the end on page 6 of the LSO's working draft, the term of office for all central committee officers shall be 2 years and shall begin in the month of March of the odd year election and end at the conclusion of the next odd year election. It outlines a term that those officers get to participate in the county central committee. This has not been an issue at the state central committee because state law covers it. It shows what their term of office is. But people, once again, have been exploiting the language that is currently in statute and utilizing, and I hate to use the phrase, lawfare for political gain that we see happening at the grassroots. Regarding Representative Yin's comment, Mr. Chairman, earlier, I just wanted to point out to him, in my particular county, we have 86 slots for precinct committee people. We only have 5 vacancies. Of those 86 of those filled 81 positions that we have, each of those persons live in their respective precincts. So if somebody fills a vacancy, it is somebody who lives within that precinct. That is state law, and that is also in our bylaws. So we don't go picking people from throughout the county to fill a vacancy. It is very, very specific when we fill those vacancies. And then lastly, I would just like to point out, and I certainly would leave this up to the committee to make a decision. I looked at 22-4-120, and that has to do with the certification of presidential elector nominees. Currently, in our county central committees by state statute, we are not required to notify the Secretary of State of who our elected precinct committee members are or appointed precinct committee members are, nor our officers. We are required to notify our county clerks, and we are required to notify the executive director of our political party. And I believe that is a requirement of both major political parties here in the state. So once again, I go back to that KISS acronym. If we go into 22-4-120, we're complicating and adding another step going to the Secretary of State. So I would ask the committee, Mr. Chairman, let's keep it simple. These are some quick, simple fixes in statute to change some verbiage and nullify the ability of individuals for political and sometimes personal gain to exploit the vagueness in state statute. We are a grassroots organization. None of our precinct committee people or officers are paid. We have no powers outside of our organization. We do this because we love our country, we love our state, and we want to serve in a capacity to benefit our counties, our communities, and the state of Wyoming. And Mr. Chairman, that's all I have to say at this time. I will be available for questions if anyone has any for me. Thank you, sir.
Thank you, Mr. Vanetta. Ladies and gentlemen, we have a bill here that has been duly noticed that has changes to line 5 and 6. It's a simple bill. We are being asked to stray and bring in other parts of the statute that we have not noticed in our process. So with that, I open it up for questions for Mr. Vanetta. Of Mr. Vanetta's proposals, one falls within this language and deals with the properly appointed and ratified precinct people that would go on line 5 of, I believe that's page 2 of the bill. So it seems ripe to me to be considered, and maybe not. But other changes, other bigger changes to party policy are way beyond the lift that we have provided notice to the public about. And so with that caution, I open up for questions. Seeing no question for Mr. Vanetta, anybody else online like to testify?
Mr. Chairman, there's no one else.
Okay, anybody else in the room? Seeing no one, you've heard the public testimony committee. What is your pleasure?
Move the bill.
Move the bill.
I think we've got a motion by Steinmetz. With a second, I'll give to Weber. Discussion.
Mr. Chairman.
Senator Landon.
Mr. Chairman, thank you. I know that we're crowding 3 hours over, but it would help me to understand the origins of this bill. I mean, when I saw the agenda, I was interested that it was on there. I just didn't remember where it came from and why it's in front of us today. That would help me to understand, and we've spent quite a bit of time on it already. I agree with your thoughts. All of this deserves far more attention than I think this committee can give this today. But that's just where'd this come from?
It was at the end of our last meeting. We were discussing parties and Mr. Crenti, was it you? I can't remember who in the audience made the suggestion, but it was not a member of the committee. It was someone in the audience made the suggestion that we have a bill draft in that area. Do you recall, Mr. Anderson?
Mr. Chairman, I believe it was Representative Weber.
Yeah, okay. I'm sorry. I remember someone in the audience bringing it up and
Okay,
so
thank
we
you.
had the bill drafted. We agreed to have the bill drafted, noticed and put forward on this meeting. And the genesis, there is controversy. There has been legal ramifications and wrangling between particular counties and about who should be voting in their county party activities, and whether the makeup of the county central committee is proper or not, based on the inclusion of elected officers which are not central committee, precinct committee men and women. I think that's kind of the nutshell of it. It's caused controversy. This would settle it in one direction. It could be settled in the opposite direction. But I think there's disagreement as to whether this existing statute is clear or not. I hope I'm being fair. If anybody thinks that that's not fair, so this is in an effort to clear that up by saying that elected party officials are also entitled to vote in county central committees. Senator Landon.
Mr. Chairman, thank you. And I just simply didn't remember. I appreciate it, Representative. I didn't remember you suggesting this. If you're ready for proposed amendments, Mr. Chairman, that I agree, 5 and 6, that's where we should pay attention to. I would offer the Coretti amendment there because I think it's more inclusive and I think it's perhaps the way that I would think we would want to go. So I would offer that as an amendment.
Can you give the language?
I don't think so.
Mr.
I'm
Anderson.
gonna probably need some help with that.
And I may have missed it, so if Mr. Crenti can correct us if it's wrong, it would replace the new language with "and of any other party officials provided by the bylaws of the party who have been certified and recorded by the Secretary of State under 22-4-120.
That is correct. That's what I have.
We have an acknowledgement from Mr. Corenzi in the back of the room. Is there a second to this proposal? I've got a second from Weber. Discussion?
Mr. Chairman.
Representative Yen?
Yeah, Mr. Chairman, I think that this is a good change. I'm frankly not super pumped about adding new people to the central committee, which is what the bill does regardless. This limits it at least to the ones defined in state statute of what state and county party officers are. But without it, you could add, a party could add any number of officers and just add them into the central committee with the language that's currently in the text of the bill. So, thank you.
Anybody else?
Yes, Mr. Chairman.
Representative Weber?
Thank you, Mr. Chairman. At the end of the last meeting, I know that Representative Yen and I he was on Zoom, I believe, and had made a comment about Title 22 and changes. And I definitely agreed with that, and that's how this came up. So I appreciate the good work on this committee and then everybody involved. And I agree with the added language. Thank you.
Thank you. Anybody else? My reaction is that there's nothing really magical about 22-4-120. There's still the party decides that. They're not elected precinct people making these decisions. So I'm not sure that's an improvement for me. I do see that it's a limited list of party officers, but I don't see that much improvement in my mind. Not meaning to. So, ready for the question on the amendment? All those in favor of the amendment to refer to the language of 22-4-120, please signify by saying aye.
Aye.
Any opposed? I think I'll be opposed. That looks like that's carried. Anything else on the bill? Senator Landon, then we'll go to Representative Yin.
Mr. Chairman, I agree with you. I don't know that language helped us a great deal. I've got some real reservations about this bill. I'm inclined to support it and move it, but my preference would have been to take it up all at once. And I think this committee can do that over the course of the next interim and do a much better job and do a deeper dive and make sure we know what we're up to. I tend to agree with Ms. Simmons. I think this is kind of a knee jerk. It's one little spot, and that's pretty dangerous. So that's my caution. Thank you.
Thank you, Senator. Representative Yin.
Mr. Chairman, thank you. So, I mean, my ask, I think, when we had our planning meeting overall was, let's talk about parties' roles in Title 22 overall. And so, with the consideration of what would it look like without parties in Title 22, I actually think that maybe the tighter focus, as Mr. Carenti suggested, on what do political parties look like on the same level with major and minor, could be a better solution for where we go moving forward. And so probably we'll bring that as a suggestion for our next interim planning meeting. I think this makes new problems. So think about our US Constitution. The House of Representatives could choose a speaker that isn't a member of the House. In our Wyoming Constitution, the Wyoming House Speaker actually has to be a member of the House. And so the question, I think, within the statute is, do we want to let people who are not elected by the people directly be also part of the party central committee membership, where they also have within that the voting privileges of the central committee among filling vacancies, et cetera. So that's the policy question. I haven't asked my party what their position is, because I don't think we very often elect members outside of the party central committee as party officers.
You mean outside of precinct?
Precinct committee, yeah,
we gotta be
current
careful
precinct
on the
committee as
language.
party officers.
Yeah.
And so including them as central committee members, I don't think was an open question for us. So it does have ramifications in other places than the one party that we have discussing today. And I'm not sure what their position would be. So as such, I mean, I'm probably not going to move this forward until knowing what that position would be. And I'm also just reluctant to give more power to folks who weren't directly elected as precinct committee people.
Thank you,
Mr. Chairman.
Representative. Thank you very much. Anybody else? Anybody else?
Mr. Chairman.
Representative Weber.
Thank you, Mr. Chairman. I think this is a good step in the right direction to level the playing field for all of the parties to be on the same, to have the same rules. And I've been a member of this committee and this body for a short time, and I see us working on all kinds of state statutes. And we often pass things that fix or correct one problem at a time. And this is not unusual, and it is not abnormal. This is a normal process. Title 22 is gigantic. I don't even know if we could have addressed it this one time. I will be supporting the amendment and the bill. Thank you.
Thank you very much, Representative. Anybody else? Let's go ahead and move forward then with the roll call. I do point out that other changes could be made as individual bills. The reason I'm adamant that we don't need to broaden this is because it hasn't been properly noticed for the public. It's not part of the process. So but let's call the roll call on the bill as amended.
This is a motion to sponsor 26 LSO 185, political parties, county central committees as amended. Senator Boner excused. Senator Dockstetter?
No.
Senator Landon?
Aye.
Senator Steinmetz?
Aye.
Representative Brown?
Aye.
Representative Heff?
Aye.
Representative Johnson?
Aye.
Representative Locke?
Aye.
Representative Lucas?
Aye.
Representative Webb?
Aye.
Representative Weber?
Aye.
Representative Yin?
No.
Co-chairman Knapp?
Aye.
Chairman Case?
No. So that is also passed. All right, we're finally done with election stuff. And now it's going to be refreshing to talk. It must be 9:30 in the morning and we're going to talk about 911 funding. Mr. Anderson. Feels good, doesn't it, to talk about 911 funding? Mr. Anderson.
Good morning, Mr. Chairman. Josh Anderson, LSO. This is 26 LSO 183. So at the last meeting, there was a request for a bill to establish a grant program for 911 funding. The amount and the source of the fund it was left blank at that time, and so it's blank in this draft. Certainly, potentially a number of different ways to implement a grant program. So this draft was the option we came up with. Certainly some policy choices that the committee could make there. So, Mr. Chairman, on page 2, provides that from funds appropriated for that purpose, the Department of Transportation is authorized to provide grants to a governing body to transition to or operate a next generation 911 system or similar internet-based 911 system that allows additional communication with the system through text, images, video, and other communication methods. Any subsection B, any governing body that currently operates a 911 system may apply to the department for a grant necessary to transition to or operate a next generation 911 system. The governing body shall submit an application describing any necessary changes to the system to transition to a next generation 911 system, the cost of the changes, cost to operate the system, and other information required by the department. The department shall approve a grant for any amounts requested in the application that the department determines are necessary to transition to or operate a next generation 911 system to the extent required by the application, and to the extent funds are available, the department may approve an application for 1 or more additional years to provide ongoing funding, and then requires rulemaking by the department as necessary to implement the section. Subsection C, if funds appropriated are insufficient to provide full funding for all approved applications, the Department of Transportation shall reduce distributions proportionally based on the total amount of funding and the total amount of funds available. Staff comment there, committee could consider providing some kind of maximum amount of these grants. One option could be basing that on the amount of funds that the governing body currently receives for 911 funding under 169103 and 169109. Over to page 4, Mr. Chairman, just a conforming change, and then a requirement that the department begin accepting applications January of 2027. And I think I picked that date mostly in case there was limitations based on the amount of funds received, so that it would give the ability to determine that amount. And then section 4 at the bottom of page 4 is the appropriation. As I noted before, the amount of that appropriation and the account are currently blank, and others in the room may be able to determine at least that dollar amount that may be necessary for this. And then it would, at bottom of page 4, as currently drafted, that amount would be, the intent of the legislature would be to include that in their budget request for the next biennium. So that's the bill as drafted. Mr. Chairman, I'd take any questions.
Thank you, Mr. Anderson. Questions for Mr. Anderson? Senator Steinmetz.
Thank you, Mr. Chairman. And Josh, I'm assuming that this leaves the current funding system intact at 75 cents per phone line. And then this would be an additional account, and it would more be for next generation 911. It wouldn't take care of the system as it is now and the deficit. Could they use it for that as well, or is it just for the next generation?
Mr. Anderson?
Mr. Chairman, so the first part of the question, it does not change the 75% or 75 cent fee or the 1.5% on prepaid wireless. As to, I think as it is drafted, it's primarily intended for that next generation. Costs could certainly, that'd be a policy choice if you wanted to open it up to fund current 911 systems.
Senator Steinmetz.
And Josh, could you remind me, or maybe someone else has the number, is it $3 million that we're in a deficit for our current 911 operations?
Mr. Anderson, if you
Mr.
can,
Chairman,
somebody else will be able to help us.
I
think.
believe I'd defer that to someone else in the audience.
Okay.
Have better numbers than I would.
Anybody else have questions for Mr. Anderson? Thank you, Mr. Anderson. Who would like to testify on this bill? Who would like to testify? Mr. Spolinsky, welcome.
Mr. Chairman,
Welcome.
committee, thank you. Appreciate the opportunity here. Senator Steinmetz, to answer your question, yes, 3 million is the estimated current deficit across all the counties. That number does fluctuate that we've seen over the years based upon expenditures. Collections stay pretty flat right now. Mr. Chairman, what I'd like to do is actually maybe take this in a little bit of different direction. We greatly appreciate the committee's continued work and willingness to address the challenges surrounding 911 services that we've talked about.
Why, did you actually say your name and who you're with?
Mr. Chairman, I apologize.
Thank you, Senator Landon.
Nate Smolinski, CTO, 911 coordinator for the state of Wyoming, and also
C2O,
for YDOT,
and what does that mean?
Chief Technology Officer.
Thank you.
Mr. Chairman, let me slow down again. If I speak in too many acronyms, we've had this discussion before. Please reel me back in.
Yeah,
I do
we
have a
don't
tendency.
live in your world every day.
You're lucky for that, Mr. Chairman.
No, you're lucky. Go ahead.
Mr. Chairman, noted. I like to just kind of read here just a little bit here. So after working with our stakeholders and industry partners on this topic, we believe it would be most beneficial to gather additional information to answer outstanding questions, more accurate information, and amend this bill for an appropriation to conduct a formal study. What we're asking to do is have a study that would focus on some of the following topics. Governance and roles. We need to clarify the roles of the state and local entities. We also want to look into expenses and costs, identify the associated costs for implementation, migration, and the ongoing operations. We want to look at operations. We want to examine various solutions and models for 911. There are several different vendors and different possibilities and models that are out there that we'd like to take a little bit of a deeper dive on. We also want to look at the technologies. Part of that is going to be taking an accurate inventory of what we have in the PSAPs right now, and also the other technology options that are out there to ensure that we have interoperable communications between the PSAPs, but also reduce any waste that might come our way. What we don't want to do is put the cart in front of the horse. Efficiencies. This has been a hot topic. We've talked about it quite a bit, and I don't think we really landed on a dead answer, but I think we can explore a little bit more about what the pros and cons of what regionalization, consolidation, and what other possibilities are out there. We talked about some efficiencies that can be driven through technology. We need to expand upon that a little bit more. The big topic that we talk about is funding. We want to investigate potential funding opportunities that would make sense for Wyoming. The one-time shot to get us over there, the current deficiency that we're at, but also what's going to look like moving forward. What are the ongoing costs that we have to consider? And then also provide some guidance that would allow for, once we have this information, what does an RFP and RFI look like? Exploring these topics and models and subsequently receiving a comprehensive report would be extremely beneficial in allowing us to make an educated suggestion to this committee. We all want to do this once and we want to do it correctly, and I think that's pretty important. So what we're recommending is that an appropriation go through YDOT, but allow the Public Safety Communications Commission to be authorized to lead and oversee this effort with the study itself. And that would be through a third party, obviously. Mr. Chairman, I'll be happy to stand for any questions on that statement.
Okay, questions? Let me just, do you have actual language that you would like to?
Mr. Chairman, I do.
Okay, so there's a little bit, it might seem like a bait and switch here, you guys. I mean, it is kind of a big change, but I think it's more germane perhaps than going in an entire different direction. And it's, and we have a lot of stakeholders here to testify about this proposed change. So I think it's useful to progress on this, if that's okay with everybody. Okay. I mean, it is a bit of a lift, so discussion. Senator Landon, I can see that look on your face. I know
Mr.
that.
Chairman,
look.
yeah, I agree with what you just said. I'm intrigued by the suggestion, Mr. Smolenski. I'm just curious, it might help real quickly as we discuss whether we want to go this direction. What kind of time frame is this going to take, and how quickly can you stand this up? And is it your vision that you would work with the Corporations Committee throughout the next interim to stand up whatever recommendation comes out of that effort? Do I read that correctly?
Yeah,
Mr. Smolenski.
Mr. Chairman, Senator Landon, you're correct. Part of what we're asking to do with the amendment would be to make this effective immediately upon approval. So if the bill were to go through, we would make it effective immediately. That would allow us to engage in an RFP process. Ideally, we can move pretty quickly by working through session to have a draft RFP in hand. And upon approval with the funds ready, we could then go ahead and start to get a vendor lined up. It would be fully our intent to continue to keep this committee, and we'd like to continue to work with the committee, bringing the results of the study to this committee for recommendations, suggestions about how we would move forward. Part of the amendments that we also did, pardon me, but the dates were mentioned. We wanted to compress those dates a little bit as well. We want to move quickly on this. Ideally, through the interim, we'd be able to report back to you progress that's being made.
Senator Landon.
Mr. Chairman, I'm a little bit confused on an RFP would go out to provide us with the consulting help that we would need to have. Am I understanding that correctly? We wouldn't be bringing on board somebody to transition us to 911. We're talking about getting someone here that can get out across the state and help us understand, what we've got to stand up, correctly?
Maybe give us a plan.
Does that make sense?
Mr. Smolenski.
Mr. Chairman, Senator Landon, you're absolutely correct. And maybe I might have blurred the lines a little bit there, and I apologize. So we're probably going to look at potentially 2 RFPs, one in the short term that's going to get us the study. And then what's going to happen is once we have that report, we'll be able to come back to this committee, make a recommendation to now start to implement and move forward. But the short term of what we're talking about today is in order to us to move forward for a study.
Senator Steinmetz.
Thank you, Mr. Chairman. So thank you for that number so that we know what our deficit is. And if we recall, last meeting, we had this discussion about trying to help with the services we're currently providing. And do we want to transition to next gen 911 when we've got $150,000 house we can't pay for, but we want a $500,000 house that we still can't pay for, and how are we going to do it? And I had proposed a bill to raise the fees on phones from 75 cents to $2, and we defeated that because we wanted to keep everything on the table. So my question is, what are we going to do right now for the communities that are struggling to provide 911 service? We know Torrington specifically provides for the entire county, and they're running at a big deficit and with a hard time trying to fund that. I could bring an amendment of how we could make this to fund the operations of 911 right now and run it through the Department of Transportation and put an appropriation on that. I have an amendment to amend this bill to do that. We talked about using tourism funding at one point, but I guess before I'm comfortable moving forward, I really want to have a discussion of how we're going to pay for what we have right now.
Mr. Smolenski, if you can.
Mr. Chairman, I'll take a swing at that. Senator Steinmetz, that's part of the reason why we want to move towards a study. We've had several discussions over what funding options might be, just as you had mentioned. We looked at a fee possibly increase there, as you had mentioned. We also took a look other models that we've seen in various states. And what we were not able to do is really come together and say, hey, we've got a good option here, or put together something that we could bring to this body to say, these are the options that seem to make sense. And we think we need a little bit more work in that space, which is what we'd like to be able to do to make sure we're going down the right path.
Absolutely.
Thank you, Mr. Chairman. And so it's my understanding, and from the research I did, it's pretty much across the board, across the country, the way we decided to fund 911 was through the telephone fees. There might be some supplemental here and there in other states, but that was kind of to keep it consistent, how we did it all across the nation. You know, we know that we have tourists coming in using I-80 that our phone service people are, probably providing for, but when we go to another state, the same thing happens there because we're using their interstates and we might need 911 there. And so that to me is why the phone lines made sense, because we cross state lines all the time. We may call 911 from any place in the country. So I guess what I'm looking for is what we can do this year in a budget session, because it is a budget session. If we need an appropriation to kind of, plug the gap and get us through, do we need $3 million to try to keep these essential services in our communities? What are we going to do right now while you conduct your study?
If you want to take a swing at it, I might make a suggestion. Let's look around the room here and let's think about putting the study together, but also in this bill having some component of emergency bridge funding that local jurisdictions could apply for right now. Okay, and you'd be very good at, with your experience on appropriations and kind of your idea, kind of fits the grant funding model. And, those two concepts would be divisible. They'd both be within the bill. We could take one of them out or not. But that would allow us to move forward this idea of a more general study, which could give us some important answers down the road. But if we retain the grant piece for emergencies in the sense of communities that are just up against it right now, like your community, and have a source of funding available for them to apply for. So maybe have kind of two pieces of this bill. And as I understand the grant funding, it's not sourced from telecommunications. It's going to be, it would be general fund. It'd be an appropriation. So that should maybe eliminate some opposition there from our friends in the room. That would be the framework of a possibility. It's kind of a big lift. Mr. Smolensky has language that probably nobody's seen, but it seems reasonable and doable in the big picture. Mr. Co-Chairman.
Thank you, Mr. Chairman. So I just have a question to clarify. Currently, this is done across the state locally. You feel that this is a core service of state government and falls under transportation, the transportation department, and would like to come up with how it's to be funded, what that funding might look like. And so I agree with the chairman's idea, but I wouldn't put a huge amount of money towards an appropriation ask, just enough to kind of bridge that gap and get to a level where we start from a basis in this endeavor. So could you comment to that?
Mr. Smolensky.
Mr. Chairman, Representative Knapp, a few things that probably I would like to just comment on. Number one, I think that's a fine policy decision that you folks can make for gap funding. You made a comment there, Representative Knapp, about being in the Department of Transportation. That's part of a challenge and an issue that I do see. I don't know if this is actually the right place to have some of this funding being driven through. For those that were all familiar, the department itself, the agency, we have some funding struggles that we're going through right now. and I do not want to have the two of these cross paths. So with that, as part of the study, I had mentioned governance as one of the items we want to look at. That clearly fits into governance. Where does this belong properly? I don't want to speak for another state agency. That is not my role, but there might be some other ones out there that might be more equipped and maybe have the resources on hand to handle a grant style program. And that's something I think we can probably further engage in as we keep working here. That would be something we need to take a look at.
So I think this ended up in YDOT's plate kind of because of, YDOT has technical capabilities. We had the WyoLink effort. Law enforcement gets coordinated, and that's kind of where it happened. It may not be the best place. It might be better at Homeland Security, for example. It might be emergency management. It might be more in that field. So, and there is an advisory committee on 911 that has various members. So it's not necessarily a YDOT bailiwick. I don't think they were asking for this originally. We just kind of stuck it to them. And so, is that fair, Mr. Smolinski?
Mr. Chairman, spot on, and thank you.
Thank you. Okay.
Mr. Chairman?
Senator Landon.
Mr. Chairman, I guess I would ask how the committee might be helpful to what you envision here. Is it, are we kind of constructing a bill on the fly and would ask Mr. Anderson to help us with that? I guess, I want to be able to make a motion that might be helpful to you, but I like where we're going.
Yeah, I'm not sure I see the exact clear path because it might be more work than we think. There is a possibility that we could just, we definitely want to take public comment today, and we want to see if we can put together a bill. We should look at Mr. Smolinski's language. If it just seems like too big of a lift, then we could break it down and we could do it as individual members. Put together a group of us to work to do it. That is a possibility. And it could be that's a plan B that we might have. So maybe we should hear, can you present the language, and is it available for the folks in the room and online?
Mr. Chairman, I have some draft language I can offer. A little bit of the challenge that's come up here is if we started talking about there's maybe one or two ways we can split this. One of the items that I did work on was strictly just a study. So with that, with the
It doesn't have the grant part.
Correct, but I took a stab at that as well. So the study aspect, what that basically does, it just basically changes almost the word grant and just puts study and talks about what we would do for the study itself. I also took a stab at it where we're adding the word study into this, and it really doesn't change much at all. We're just changing some of the dates. Like I mentioned, we would go effective immediately. This way we could ramp the study up.
Can you go through
We
it?
can go through that if you would like.
Is that okay, you guys? Let's just go through them. Tell us the changes you'd make.
And Mr. Chairman, please, a little bit of forgiveness. This is a draft.
Yeah, of course.
So, Mr. Chairman, starting off on page 1, line 2, after the word grants, we would just add "and a study."
Grants and a study?
Correct.
Okay.
And then, Mr. Chairman, we're going to move over to page 2. I'm going to take a liberty and just strike out on line 2, Department of Transportation, and we can maybe keep that open-ended at this time.
Okay.
And then, Mr. Chairman, I'm going to move down to line 7 and add another line is that the department is authorized to use a portion of the appropriation to conduct with the Public Safety Communication or to coordinate, I apologize, with the Public Safety Communication Commission to conduct a study.
Okay, it's interesting you used department there, but yet you want to take department out at the beginning. So
Well, it
that's,
could be the Department of fill in the blank, Mr. Chairman.
okay. All right, keep going.
And then also, I did have some language that we had wrapped around about what we would be trying to capture in the study. And I can share that as well, because that can be applied directly after that last sentence.
Go ahead.
What we would be looking to study is examining the transition to next generation 911 within the state of Wyoming to include, but not limited to, governance and roles, expenses, operations, efficiencies, technologies, and funding options and models.
Okay.
Mr. Chairman, where did he put that?
He put it at, we're still before B. We're in the blank space between line 8, basically, on page 2, right?
Mr. Chairman?
Mr. Chairman, you're correct.
Who's speaking? Oh, sorry, Representative Weber.
Thank you, Mr. Chairman. Would it be possible that we could get a copy of this?
Yeah, I'm hoping,
Mr.
let's go through
Be
it
a
once
lot
and we're gonna
easier.
get him to give us a copy.
Thank you.
By all means, Mr. Chairman, I will.
Yeah, okay.
Moving on to page 4. This is just some conforming language. On section 3, line 7, again, it says the Department of Transportation. I would ask that we just follow what we did previously and just keep that open-ended right
Okay.
now. And then, Mr. Chairman, moving down to section 4, line 12, that's probably the big question as far as the amount of dollars.
Okay.
And now with that, we knew that we were talking roughly at about $3 million deficit. If we were strictly looking at gap-style funding, that would be the number that we've been speaking with this committee for a while and what we have on paper to show. I have estimated at max, we would probably look at, I would ask for $750,000 to conduct a study. I don't think we would go over that, but I would still say that would give us some headroom. And then again, Mr. Chairman, just on line 13, some additional conforming language wrapped around the Department of Transportation. Line 14, after it speaks about the period beginning, we would just turn that into immediately. And then on line 15, I would move the date up from June 30th, 2028 to 2027. And that would be focused around the grant distribution, if that were to still take place for the gap funding.
Okay.
It would be our intent to have a study completed well before that time period. And then again, Mr. Chairman, just some conforming language under on line 16, the governing bodies. After that, we would just add "and to conduct the study." This just talks about the funds that would be made available. And then moving down to line 23, again, some conforming language wrapped around removing the Department of Transportation. And then finally, to wrap things up on page 5, section 5, line 4, we would just have that this act is effective immediately. There's a lot there, but it's
I kind of get it.
not as complex.
So are you reading off notes on a page? Is that what you were reading off right there?
I am, and Mr. Chairman, I'd be happy to share this. Well, I'll be happy to clean this up and get draft over.
Is there any way we can get copies of that document that he's referring from? You guys? Would you be able to do that, Heather? And I'm sorry, someone's got to do it, and thank you. So now you surrender that. Hopefully we see it again. Senator Steinmetz.
Mr. Chairman, while we're working on that, wouldn't we want to delete that it would be included in your standard budget as well? Which I don't think we want to include it in the standard.
I understand what you're saying. Mr. Smolinski.
Yeah, Mr. Chairman and Senator Simons, thank you for pointing out. That's just a continuation of that last line from 23. That'll carry over to page 5 as well, line 1 and line 2. So thank you for pointing that out.
Your voice dropped off. Would you say that again?
Absolutely. That was a continuation from page 4, line 23, when we mentioned knocking out the Department of Transportation. That would just carry over to page 5, lines 1 and 2.
Okay. So everybody, we're kind of at a disadvantage without the actual language here. But could we, if there are no more questions from Mr. Smolinski at this very moment, could we start taking public comment on this concept? Yeah, I'm sorry, go ahead, Representative Heft.
Thank you, Mr. Chairman. Mr. Solinsky, do you know of any critical items that need to be addressed in our 911 system in the state? Is there anything that's impending failure?
Mr. Smolinski?
Mr. Chairman, Representative Heft, it's a very good question. We're at various states. So I think we do have some technology, some services out that are suffering more than others. And part of that has to go with when we look at where some of these counties and some of the public safety answering points, which I call PSAPs, Some of those have been possibly better funded than others, so they might be in a better spot. I will touch on right now, I was informed on Friday that there was an outage up in Sheridan that just recently got resolved. Went down on Friday and just got resolved late last night, early this morning. And they were down, what we call down hard. So all the calls were being reverted to Buffalo and Johnson County. Now, part of that is there's various upgrades that are trying to take place. So there's degrees of critical infrastructure that's out there, that it's aging, it's older. If you were to ask me right now, do I have a whiteboard in my office that says if I had X amount of dollars, we're going to take care of this? I do not have that right now.
Go ahead, Representative Heft.
Thank you, Mr. Chairman. So this $3 million deficit, is that caused roughly by trying to keep up with the maintenance of what we have right now?
Mr. Smolinski.
Mr. Chairman, it is. It's just the ongoing cost as well to operate. We have to remember that those funds that we talk about, the 3 million, that is coming off of the 75 cent per fee, which is coming off your line right now. And that was set back in 1986, 1987. So that's part of where the challenge comes in, that just inflation and the way that the technology has grown, it just hasn't caught up yet.
I think it might be useful to remember, though, that fee is not all the funding for 911. It's a contribution to the local governments that provide the service, but there are many things, including personnel, equipment, things. It's a much vaster thing. This contributes towards that, but so do other funds from local governments. And it may be our intent someday to say this would be the 100% funding for it. But that has never been in the past. It's been a combination of monies from local tax revenues and other sources and the 911 fees to provide this service. So consequently, that's been a bit of difficulty for me because we've never had a really good accounting of how the money is spent. And we've kind of gone around that and required reports in the past, and it's been a struggle at times. And Heather, we're going to have extra for the public if you're the best. Thank you very much.
Mr. Chairman, committee members, I apologize. My chicken scratch is written on there, so.
Yeah, it's actually not bad. You're not a doctor, and it's not overwhelming. So we're going to let the public get a look at it. And I'm sorry, Representative Locke, I apologize.
Thank you, Mr. Chairman. I'm sorry to kind of ask almost the same question again, but I just want to understand, because the question was asked, is this just maintenance? Is this just holding up what we're doing? Is that what the 3 million is? Are there things, but you mentioned just right before that there's upgrades that are happening. And so that's another question that I'm kind of throwing out to Mr. Smolinski as well as others. Is there something to this process we need to consider? I'm just throwing it out where we need to say, hey, listen, if we're doing a study, are there upgrades that need to be, we may not have the control, but should we be upgrading things when we're doing a study to say, how do we really want to do this? It might come to consolidation, centralization, and other kinds of efficiencies. And so there's a whole bunch of money potentially being expended out there that we could take a good hard look at and say, does that make sense? I just wanted to throw that out to the committee as well as to Mr. Smolinski, if you have an opinion, because that whole, hey, it's just maintenance, hey, it's just something we're short, but at the same time, I'm hearing there's upgrades happening, and I wouldn't be surprised at that, and I want to throw that out. Thank you.
That's a really fair question, and Mr. Smolinski, before you answer, I might add that this approval group that provides the grants, they'll probably be taking that into consideration. I would think that would be the direction, but Mr. Smolinski.
Mr. Chairman, Representative Locke, that's exactly what we have to be aware of. I kind of mentioned, hey, don't put the cart in front of the horse. We want to make sure we're reducing waste. We also want to make sure that we're going to maintain interoperability. So if an entity were to come forth and say, hey, we need some dollars because we need to do an upgrade, we have to evaluate what that upgrade for. Is it critical? Does it need to be done because it's a system that is going to fail? If it's just we want to upgrade because I want the shiny new, That's not really a need at that point. That becomes a want. So that discussion's going to have to take place by that award committee.
Representative Weber.
Thank you, Mr. Chairman. Thank you, Mr. Smoletsky. My question is, I'm sure that you've been doing this long enough that by county, who has already upgraded and what upgrades still need to be done on some of the other counties who maybe don't have enough funds?
Mr.
And going forward.
I'm sorry, go ahead.
Thank you, Mr. Chairman.
And going forward.
For the study, it would be very helpful to even look at what funding would be needing specifically for each county, as well as the funding that's coming in through other methods other than taxpayer funds. Thank you.
Mr. Smolensky.
Mr. Chairman, and maybe take a stab at the first part of your question, Representative Weber. We have conducted some inventory surveys when we've sent information out to the PSAPs, to the counties, and they've replied back. We're asking for items about what type of call handling or what type of CAD are you using, computer automated dispatch. Now, what we found is that it's a little bit all over the board, but we don't have enough of that data yet. Certain counties that have a larger budget have been much more proactive. And I'm going to kind of back up a little bit. They're buying some equipment that is what we call NG 911 capable, so next generation 911 capable, but they're not able to take advantage of all the features. If you remember back to April, we had Monty McLean from Park County who sat here and he used a really good example about you just went out and you bought a brand new smart TV, has all the bells and whistles, it's great, but you brought it home and you have a really bad internet connection. So you're not able to take advantage of any of those features. That's kind of what we have at various levels of the PSAPs. So going back to the upgrade question, some of these PSAPs were in a situation where they had to make replacements. They had to replace a piece of equipment for call handling and how they're able to send out text messages and various technologies. So at that point, they did go out and buy the piece of equipment because it became critical at that time. So to go back to what you were saying there, part of the study will be to conduct a comprehensive inventory of where each PSAP is, what equipment they have, is it going to be interoperable with what the solution is going to look like? And that helps determine the level of funding they may or may not require for that individual county. I hope that answers the question.
We good?
May I make another comment, Mr. Chairman?
Certainly.
It surprises me that the 911 system isn't new in Wyoming and that we don't already have a current list by county of what each county currently has that's working, not working, or have been replaced. Thank you.
Mr. Smolensky, you're welcome to comment.
Yeah, Mr. Chairman, Representative Weber, the system is working right now. What we find, though, is that when it goes down, it's becoming more challenging to keep it up and running. And as I made a mention, we do have an idea of what each county, remember, it's locally driven. It's driven at the local level. So the information that we're able to collect from those counties, that's coming purely from our relationships with those counties, that we're able to go into their centers, sit down with them and have that discussion. There's no mandate that they have to provide what they're doing inside their own walls. So we try to get that information the very best we can. We do find out, hey, Lincoln County is going to go out and they're going to replace something because they have an issue with some technology. So we do have that, but it's a very informal conversation that we're having, which is why we want to look towards something that's a formalized study in this nature.
Thank you for the information. Thank you, Mr. Chairman.
Absolutely. Anybody else from Mr. Smolensky? Representative Lucas.
Thank you, Mr. Chairman. Please forgive me if I am overly simplistic or not catching on, but when I first read this bill, I'm looking at authorizing applications for grants to transition to and operate next-gen services. So that made me think that, oh, we're ready to move on this, but we don't really know what we have or what we need to do yet. So now we have a study. And then as I'm puzzling through this, I'm seeing that this is a major transition on this bill. And is this something that we are equipped to deal with today? This is our last meeting. And so then I'm just kind of wondering, well, how are we going to do this? Thank you.
Mr. Smolensky?
Mr. Chairman, I'll try to speak for the committee the best I can, but That's part of the reason why we want to capture some more information, Representative Lucas. We need to have a better idea of what this migration is fully going to look like. Part of the challenge, and I mentioned them a little bit briefly with the way the bill is drafted right now, we at the Department of Transportation, we don't have the resources right now to go ahead and effectively and efficiently administer a grant program with the way that this is structured. We'd run into some challenges right there. As a reminder, my role as the 911 state coordinator is literally to coordinate and have a roadmap to migrate the state to next generation 911. That's where it starts and stops. So we've already kind of gotten out in front of our skis, so to speak, about taking on more and more, and as we've captured this information and as we're trying to bring these parties together. So we're trying to set back a little bit here, and with the help of the study that we keep mentioning, what that's going to hopefully provide us is some of the tools and some of the resources that would then build this map out a little bit better to get us to the next phase. What other resources have to be applied? Where do these separate roles come into play? Answering some of those questions. But it's exactly where we kind of saw as well that we're looking at the next generation 911 within this bill, but as Senator Steinmetz mentioned, we're not taking care of where we are today. And that's got to be part of the bigger conversation.
So there is this issue, Mr. Smolinski. Senator Steinmetz is concerned about existing facilities, existing operations, not an enhanced 911 world. She'd like to have the grants, and I don't mean to speak for you, but you'd like the grants to be available for right now needs that may not. And so I'm looking to this, the grants that are talked about in the existing bill all talk about future and moving to enhanced 911. So there's about 3 places to accommodate what you need is to say operate current systems and move so that these emergency grants could come forward. But that would be a potential change to your bill or to your, in addition to your amendments. I think what I'd like to get to though, and if we don't have anything else from Mr. Smolinski at this time, let's get a reaction from the public about, and the stakeholders in this as to whether this is a feasible way to go. And one last question for Mr. Smolinski. Does Homeland Security know you're trying to stick this to them? Did you talk to Ms. Budd?
Mr. Chairman, if you notice throughout there, I left every line blank and open. I never called out Department of Homeland Security flat.
Wait, this draft does have.
That draft has it as an option.
Yeah.
However, as I mentioned, when I blacked them out in the lines there, we did not put woes or anything along those there.
Yeah.
So we spoke a little bit, but we did not have the in-depth conversation. And by no means am I offering, the reason why I would have mentioned Department of Homeland Security, they work in grants specifically around public safety.
Sure.
So they're very familiar in that space. However, without Director Budd here, there's no way I am going to step in and speak for them.
And I don't think this committee should do a bill that says restrict this to Homeland Security without them providing input. So we need to be very crafty about and amend that in later. So a state agency to be named. So understand the sensitivity there, and I don't mean to step on any toes. Senator Steinmetz.
Thank you, Mr. Chairman. And I can see the wheels coming off the cart kind of with this. But one offer I wanted to make is we could take care of the emergency funding that we could possibly need while you're studying with a budget footnote is a budget session. And just make this a study bill if that was what you wanted to do, because by the time I can see how we could change the bill to do both, but I definitely don't want us to say we are going to transition. I mean, if we want to take care of, but then I think you could also talk about that it really should be 2 separate bills as well. So to me, it would probably be cleaner to look at a budget footnote for any appropriation we might need and find a particular agency who could handle it.
That's fair enough. I think that's really fair. And I think we still have the fallback position that members of this committee that are interested could introduce the bill. themselves.
Mr. Chairman.
Senator Landon?
So just one other thought, Mr. Smolinski, I would think that in our work with a consultant group, or as you go through the study, I would think that that would be a really good, appropriate place to determine whether or not we want that to rest in the Department of Transportation, or if it would be better served, moved somewhere else.
It's possible.
So I would think that would fit in the study.
You're welcome to comment.
Mr. Chairman, Senator Landon, that's exactly where we talk about governance and what's the
enough.
role. So without a doubt, that's one of the key things I want to be able to make sure we pinpoint.
All right, everybody's wheels kind of, let's hear what the public has to say. Let's hear what big law enforcement has to say. And anybody else you want to fill out the chairs, you're welcome. Go ahead, Mr. Thompson.
Thank you, Mr. Chairman. I'm Alan Thompson, the Executive Director of WASCOP, the Wyoming Association of Sheriffs and Chiefs of Police. Almost every PSAP in the state is run by one of our members. In some cases, there's a joint powers board where those members have a say amongst a board. Now, granted, it's been a long conversation this summer about a bunch of topics, and I understand the discussion has morphed quite a bit this morning. But I did want to point out from a inventory and a kind of a centralized location standpoint, there's 32 or 33 individual PSAPs in the state of Wyoming that receive their funding on a local level, and that current 75 cent per line and that percentage of prepaid all goes directly to those counties to be used for those. So putting that together into one spreadsheet that's updated on what equipment's available and what is not changes as soon as that's done. So that's kind of a big lift to get an accurate and ongoing comprised or full spreadsheet of what is out there. But the two discussions that we were having in this interim is the shortfall that we have and then the grant opportunity. And our members had a chance to look at this draft bill from a week ago, not understanding limitations and appropriateness of state agencies to run a grant system, but obviously in support of a grant system available for build out that they're already saving up for to build out. And how has it been explained to me is that the next gen 911 build out, most of the equipment that's on the market right now is next gen capable. So when they build out, they're going to be buying items that are capable of that next gen. But a concerted effort statewide to roll that out together just hasn't been put together amongst all of our entities. And then also the shortcoming that we have with funding some of our PSAPs across the state. There's a lot of general local monies that are going into running these dispatch centers. There's a lot of charges that a PSAP will make to another entity to provide their services. So it looks different in every community across the state. And having some sort of grant system to help bridge that gap while we understand better what the need of the state of Wyoming is going forward and capabilities for us to work together across the state, we would ask for that consideration going forward. And I'd be happy to answer any questions.
So thank you, Mr. Thompson. Questions for Mr. Thompson? Representative Johnson.
Thank you, Mr. Chairman. This 75 cents that is charged on every cell phone bill, where does that money go and what does that do? I mean, is that the emergency funding that these counties need, or would that get them current with their expenses and get them through the next year? Or where's it go?
Mr. Thompson.
Yeah, Mr. Chairman, by far not the expert probably in the room to speak to that, but that money is collected by the entities that provide the service and then sent to the individual counties. So when it arrives at the county, then it is applied to the costs associated with the PSAP. Now, PSAP stands for Public Safety Answering Point. So this isn't going to a deputy's patrol vehicle responding to your house. This is the 911 center, dispatch center, equipment and radios and things associated with that answering point and getting the correct services out. So dispatch in most places across the state provide a lot more services than answering a 911 call. Mr. Chairman.
Follow up?
So just the PSAPs, that 75 cents would cover them. I'm saying that you're going to have ambulance service and sheriff's departments, people call in every day. So I'm trying to separate that out. Wouldn't the counties have to pay for their sheriff's department, their ambulances and fire department, all that separately than just the call in? And I think we want to separate just the call center, keep that going right now. And maybe I'm making, help me out here, will you? Thanks.
Mr. Thompson.
Mr. Chairman, I might have confused the issue more and I apologize, but yes, that 75 cent per line and the other costs associated with the 911 payment go to the counties and are by statute earmarked for the answering point. There's a bunch of other services that occur in the county like fire, EMS, all that other stuff that's not covered by this. And you can't say, and I'm just saying that those dispatchers and the other people that are employed by the county do other things other than that PSAP. So it's hard. It's so hard to put a number on the costs associated with it and what that 75 cents is actually paying, because there's other duties and responsibilities outside of the statutory limitations of that 75 cents. And what we think right now is that there's about a $3 million deficit in what that collection is and what we know the costs of upgrades and building and paying the light bill and all that other stuff.
But that's just respect to PSAPs and their operation. Doesn't include other emergency services, which are, by what I've heard, in deficit all across the state in different crises.
Yes, Mr. Chairman.
Would that be
I'm sorry.
fair?
Yes, Mr. Chairman. Thank you.
Thank you. Representative Weber.
Thank you, Mr. Chairman. With the number that you're saying that's in deficit, how are you able to come up with that number? This is an estimate? If there is no inventory or coordination between the 23 counties or however many operations there are? Thank you.
Mr. Thompson.
Mr. Chairman, I'm not able to answer that question because I didn't collect that data. But I think somebody in the room might be able to better answer that estimate.
Would it be fair, Mr. Thompson and Representative Weber, that's one reason we're thinking we need a study, because we actually don't know all this. And different counties or local governments, they contribute different amounts to funds to it. They're able to do that, or, and some contribute less, some contribute more. We're going to hear all about that, I suspect. Is that fair, Mr. Thompson?
Yes, Mr. Chairman.
Okay, let's go to Representative Webb.
Thank you, Mr. Chairman. And I don't know if Mr. Thompson or anybody can answer this for sure, but it's a question that's hit me this afternoon now. And that is if I have a non-307 area code on my cell phone, am I still charged 75 cents even though I live in Wyoming? And where does it go to then?
We're going to have providers that are going to be able to tell you that, but I think the answer is yes, and I'm getting some nods, but we will hear from people about that.
Maybe, Mr. Chairman.
Yeah.
May I answer?
Yeah.
It's my understanding, Mr. Chairman, if you change your billing address to a Wyoming address, regardless of
follows.
if you change your phone number, that's where the collection is occurring.
That's a good
Your
answer.
billing address,
Thank you, Mr.
not your
Thompson.
phone number.
Senator Steinmetz.
Thank you, Mr. Chairman. Just really quick, I just sent the committee all the documents from last meeting. It gives you a breakdown by county of what their numbers were that were reported by each county and their PSAPs. And because it's a local control issue, right? Because
Sure.
they get the money in, they have agreements with the cities and counties, and they're all different across the state. And I love local control, so I, want to support it all we can.
Thank you. All right. I think we're done with Mr. Thompson. Who's next?
Mr. Chairman, Joey Carenti, Rural Wyoming Matters. This is definitely not my wheelhouse, so forgive the lack of fluency of an expression that you may have come to accustomed to. I'm looking at the page 3, section C, the way they step down if the funds aren't available. We haven't even figured out where the funds are coming from, how it's going to work. I agree with the study. But I'm worried that even though it says proportionately, the system may either be set up or executed to favor or disfavor economies of scale on either side. It may be more beneficial to continue to make sure that the larger projects are done first, or it might be, hey, we're running out of money. I want to take care of some of these smaller municipalities. I think that's a legitimate discussion to have if there's going to be a study or a working group, is how does the approval and then the scaling down proportionately actually work? Over on page 4, where there is a blank for the appropriation, I'm sorry, I don't have the new proposal, I'm going off the original draft. I am also concerned, we don't know exactly what, exactly who, exactly how much, or from where. And I think it might be appropriate to consider adding into this study or the conversation members of the Labor Committee, I don't know, whoever Mr. Thompson says that they should be bringing in, definitely the Department of Health and Department of Transportation, because we have almost the same types of issues going across EMS services, 911, and search and rescue, all which are statutorily required somewhere. Someone has to pay for it. And I see a couple of years ago, we had this magical overage in the taxes we collected on the lodging tax, and we went with an amenity over a service. I think if that taxation is still garnering more funds than and believe me, I know as much about the Wyoming budget as anybody who's watched budgets for 10 years, which is nothing. I don't know. But I'm thinking if we're continuing to collect those taxes and it was sold to the people of Wyoming as a burden that would be mostly borne by people out of state, and people from out of state that come to Wyoming use things like 911 services, search and rescue, and ambulances, that we may be able to create a fund or 3 funds that redirects that, and or some other creative means of funding that isn't direct taxation or fees applied to Wyoming residents. I would be happy to help. I just don't know that I would be any help on that, but that's just really some kind of layman's assessments and ideas. And rural Wyoming is hurting in some of these areas. And to see a possibility that we're going to get brand new stuff for the big guys and we're going to be left out once again, or maybe not be able to call 911, or setting up more state amenities, whether they generate revenue or not, and not taking care of the things we need to exist in the smaller, especially hardship counties, is a little disheartening. So with that, I'll stand for any questions and really hope you don't have any.
Thank you, Mr. Correnti. Appreciate your testimony. I do. There's only so much we can handle. I can't fix EMS in this committee, but thank you. Thank you very much. Let's see. Let's go. We should have got Wham probably in the beginning since you're an association. I mean, for now. Let's do Ms. Harpstreet.
Mr. Chairman, members of the committee, thank you for that lovely introduction. Ashley Harpstreet. I am the current Executive Director of Wyoming Association of Municipalities. I'm also joined with my friend, Mr. Nick Agopian here today, and I think we have some joint comments about from the locals' perspective of how this is really patchwork together between jurisdictions and locals, and why we would absolutely support a study and appropriation for underfunded services that we collectively supply to all of our residents of the state.
Fair enough. So you see a gem of an idea in here, I think. Thank you. Mr. Agopian, welcome.
Mr. Chairman, Nick Agopian with Wyoming County Commissioners Association. Kind of to build on where that conversation is going, the idea of where the $3 million shortfall has come from was a request, I think, we found out after the interim last year when this committee was looking at this issue. Again, the good reminder is this committee was tasked with looking at specifically that NG 911 transition. And as we've looked at that transition, we've realized more so where that delta is, that $3 million delta. But it's important, that $3 million delta, because you have to keep, and it's something we haven't discussed, the existing 911 system needs to be in place, operational, until the state transitions as a whole to the next gen 911 system. And the value of doing that at the statewide level is an economy of scale, we believe, something I'm certain that a study will tease out And the goal would be to purchase the least amount of equipment to provide the greatest amount of service and deploy that across the state, utilizing the new technology that's available and those economies of scale that this state has done in the past and has the ability to do in the future. And so to Senator Steinmetz's question, what do we do in the interim? That interim is real, and we do need to keep that going. This bill, where we started, speaks specifically to this notion of, is the system going forward, transitioning to this next gen 911? Is it going to, as we transition into that system, what's the best manner to do that? And how do we do it efficiently going forward? And so this idea of doing a study, doing a backstop for that funding, doing a backstop from that funding is a departure from the current setup. In 86, when they passed, put in place the statute that allows locals to go and make the decision to tax at the local level or apply this fee. But then the question would be, going forward, is it going to stay at the local level? This bill, as it was originally presented, keeps it at the local level with state funding. But what does state funding really do? It's going to hopefully standardize what's in those PSAPs based on what is the statewide service that needs to be provided. Because today those PSAPs do not have a standard, there is statutory language that's fairly broad about how to utilize those 911 fees. I don't think anybody believes that those are being misused. We just believe that there's not enough going forward. And then the disparate amounts that are reported back are because there's no standardization on what is being offered and what is required. So it's kind of hard to look and see where those efficiencies are. What is that apples to apples comparison across these PSAPs? And so this a state grant program, some state participation provides that opportunity to establish those statewide standards, help establish what the standard services are that are going to be offered to our citizens in this state. And how are we going to do that efficiently? And so in terms of looking at a study, looking at how the state can support and help, and then answering that question of, is the state going to run the system? Is the state going to provide the standards, or are the locals going to run the system under those state standards, or are the locals going to continue to run that system going forward as they see fit with those funds? Because today that $3 million delta is being addressed at the local level. And I would probably suggest that that's a low number, but that is the number we have. That's the one we're working with today, I think, as the senators thinking about how to bring forward that emergency funding to ensure we have a quality system today.
Thank you, Mr. Groping. Questions for Mr. Groping? Mr. Co-Chair.
Thank you. And this may be a question for either one of you or both of you, because just coming from a local level, I do see this as more of an equipment funding type of road to go down, because at the local level, you do have over 30 PSAPs out there. There's 23 counties. So obviously there's situations like, I'll use my own community. We have 2 dispatch centers. We've tried to combine them, but for some reason on a local level, they have chosen to operate separately, which means separate equipment, separate employees, the entire bit. I think one is more of a combined dispatch center where you have EMS, fire, sheriff's office. The other is city. So those are local choices based on local priorities, I would say, with local dollars. I think the intent of funding was to fund equipment. So I just want to get your perspective on that, how this can go down a road of if the state takes control of what is in a dispatch center, or how many dispatch centers are in a community, or that regionalization aspect, how will locals react to that?
Mr. Groping.
Mr. Chairman, I think today we are open to that idea of looking at where those efficiencies are, how to better utilize existing equipment, and how going forward to utilize shared services. Because some of the new technology itself requires ongoing maintenance of the system. I think this committee has heard at the last meeting from YDOT that that is a significant undertaking to maintain these systems. And so, moving forward with the study, that's the support for the study, is identifying what is that efficient path forward? What's a reasonable timeline to roll this out? Because if you don't have a reasonable timeline, your $3 million delta grows each year going forward. So the quicker we can do this, the quicker we can transition, the sooner we're going to be able to potentially find what those efficiencies are. But I think today we're not necessarily prepared to identify where all of them might lie, and instead would look for a clear path forward with some third-party help to identify what would work the best for Wyoming.
Any other questions for Mr. Gopian? Mr. Thompson, you came up here with a stern look on your face. Did you feel a need to react to something?
No, Mr. Chairman, but I would just like to point out Wyoming State Statute 16-9-105 is the one that talks about what that funding is required for. And to further answer a question that was asked earlier, some agencies pay part of personnel costs with that 75-cent fee. Some do not. So there's probably 33 or 32 different approaches to that, all within the constraints of 16-9-105.
Fair enough. Thank you, Mr. Thompson. Mr. Brown, it's your turn.
Good afternoon, Mr. Chairman, members of the committee. Chris Brown, representing the Wyoming Hospitality and Travel Coalition. Mr. Chairman, this topic broadly is way outside of my lane of expertise, other than the multiple references to lodging tax and tourism, which I'm here to speak on. Mr. Chairman, we would respectfully oppose the use of lodging tax to fund this initiative. When the lodging tax was initially passed, it was passed and statutorily directed to be spent on marketing, promotion, education, staging of events, and other tourism-related initiatives. And so it would be our perspective, Mr. Chairman, that this falls outside of that definition. Mr. Chairman, the lodging tax acts as a revenue generator for the state of Wyoming. In the last 10 years, the economic impact has nearly doubled. In 2014, the visitor economy generated approximately $154 million in state and local sales and taxes broadly. And in 2024, that grew to $277 million of state and local tax economic impact. It's a growing industry. And so it's our perspective, Mr. Chairman, that the more we dilute the lodging tax to fund things that don't fund the marketing and promotion of Wyoming, the more we risk impacting the positive financial impact that the lodging tax has had on the state. Mr. Chairman, I think it is absolutely fair to assume that visitors use 911 services just as much as residents do. But what's the percentage? I don't know. I haven't heard that in the testimony. And so is it 1%? Is it 5%? Is it 50%? Perhaps if the study that's been suggested goes forward, that will illustrate that, and perhaps that would indicate that we need to be part of that discussion. But Mr. Chairman, for today, we would respectfully speak against that. Actually, I did want to make one more quick comment. There was a comment about who pays the lodging tax. And when the state of Wyoming elected to take the Office of Tourism off of the general fund, it reverted $11 million annually back to the general fund to then instead have the agency be funded by the statewide lodging tax, which is paid 75 to 80% by visitors coming in from out of state. And so, Mr. Chairman, we see that as a win-win for Wyoming. I'm happy to stand for questions.
Thank you, Mr. Brown. Any questions for Mr. Brown? Representative Weber.
Thank you, Mr. Chairman. My question is, you said on the lodging tax, it's paid for 75 to 80% by people not in Wyoming. Where are those numbers at? Are they on your website that show this many people came from Kansas, this many people came from California, this many people were actually in-state travelers, maybe they were going to medical procedures throughout the state, or maybe high school games or something like that? Do you have that info?
Mr. Brown.
Mr. Chairman and Representative Weber, thank you for the question. That can be found on the tourism industry's website. It's a report annually done by an independent contractor called Dean Runyon and Associates. They are an independent analysis firm that does tourism's work each year, and that will show you the breakdown. I don't know that it'll say X amount came from Indiana or something along those lines, but it does illustrate the percentages that I'm talking about. 75 to 80% from out of state coming in, 20 to 25% paid from in-state.
A follow-up, Mr. Chairman?
Sure. We
thank
don't have a specific reach to the lodging tax in this bill. That
I
would-
know.
That would
Since
come
it came
later.
up, I figured I'd ask
Yeah.
a follow-up question. So is that
Yeah.
done by year? And is the current year 2024 or 2025 tourist season?
Mr. Brown.
Mr. Chairman, thank you. And
Thank you.
Representative Weber, it is done annually. It's typically released in the spring of each year. The report I'm referencing is the 2024 report. Done in 25 for the 2024 impact numbers.
Fair enough. Anybody else? Mr. Brown, that was a good technique of preemptive strike. I appreciate it.
Thank you,
Very
Mr. Chairman.
skillful. Thank you very much. Time out for just 1 second, housekeeping. I know all of you in the back are here for the Uniform Law Commission issue, and I know you are, and we won't take that up before lunch. There's just no chance. So, Mr. Meyer, you can have a better lunch than the rest of us, I think. I don't know when we're going to finish this. But I would like to finish this before we go to lunch and then and then probably not take an hour and a half, but take an hour. People need their time for their break and then come back. So with that, here we go. Ms. Levin, welcome.
Hello, Mr. Chairman. Jody Levin here on behalf of Verizon and Charter. I'm going to be as brief as I possibly can be. My clients agree with the idea of a study for many of the reasons that Mr. Agopian articulated. As we've gone through the interim and in the stakeholder meetings, we've asked a number of questions and we have a lot of unanswered questions. And so at this point, I would say we don't know what we don't know. And in fairness, as other states have looked to migrate to Next Gen 911, they've undertaken studies as well. It's complex to the notion of efficiencies. I mean, all of these things, many states have relied on consultants and a study to help frame out how you would do this migration so that we fully support doing a study to understand what that would look like for Wyoming. Briefly, to answer a couple of the issues and questions that were raised this morning, Senator Steinmetz, you were absolutely correct that traditionally an assessment on a phone bill has been the way that the 911 system has been funded. The problem that you have is as technology has migrated and has changed, we all know, it's dynamic, it's not static. That tax on a bill has not covered the full cost of delivering the service. So many states, it used to, that 75-cent charge used to cover the cost. Most households, I think the average household has 6 connected devices. So that's a landline, that's your cell phones, that's a watch. So you're not paying one fee per household. Chances are you're paying multiples, and if you've got kids, you just keep adding and adding and adding. So the industry, of course, has resisted the idea that what we feel is a very core government service is being funded on a customer's bill. States have looked at this. They recognize that it is no longer covering the cost of delivering the service. So many states are bifurcating the system. They're keeping an assessment on the bill in place, and then they're supplementing in state funds to help with the delivery of service. In a small population state like Wyoming, I can't even imagine how high that tax would be if you tried to fully fund 911 on customer bills. And so that has been the position of my clients is at some point you can no longer provide the cost of the service through the tax, and something needs to change. And many states have looked at this bifurcation of, some states are actually moving to full cost of providing the service. Others have looked at keeping the 911 tax, the fee in place, along with a bifurcation with state funds. And so I think that's what we were advocating at the last meeting as a possible path forward. I think the most recent state who has done this is Idaho.
Thank you, Ms. Levin. Questions for Ms. Levin? Any questions, Mr. Hendrickson?
Mr. Chairman, members of the committee, Jason Hendricks with Range, also in support of the study. I wrote down the goals as quick as I could as Mr. Smolinski went through those. I would note on page 2 that those aren't in there. Those would probably need to be filled in under the language that he has here. So, but I listened to the goals, that all made sense. Actually, I was hopeful that during this interim, we could accomplish some of that stuff. Maybe I was a little naive or overambitious, but I kind of hoped that we could have gone through a lot of that stuff. But I think having a third party do it makes sense. I think people will be much more open in providing information to the third party. And I think that third party study is also helpful for identifying what we as providers need to do with this system as we're partners into the system and delivering calls, how that works as well. So in support of the study, and the rest of the stuff on how you go about doing this is pretty complicated. So I'll probably stop right there.
Okay, any questions for Mr. Hendricks? Mr. Hendricks, I have a kind of a technical, you have more technical knowledge about telecom operations than other witnesses so far. And I was just throwing out there, as we go to enhance 911, is it conceivable that there would be some economies to be had when you move towards cloud-based transport versus dedicated circuits, which is probably the way it's been done in the past? I mean, dedicated circuits are expensive. So is there potential, or just give me a flavor for that.
Sure, Mr. Chairman. You said enhanced. I think you mean next gen. Just want to clarify.
Yeah,
that.
I'm sorry. Internet-based maybe would be the best way.
And yes, I think, and generally, I would agree with that. I would think there'd be efficiencies in operation that could be gained. Now, I do also have to caveat that, I have maybe a little bit more technical understanding just from day-to-day operations, but
Yeah.
my background is economics too, and so.
I know we went to the same school, but you've actually been more on the telecom operations side than a lot of other people that have testified so far.
But I would agree. I would think there could be efficiencies that could be gained as you go from the current system to the new system, that maybe there could be fewer PSFs, maybe there could be different ways
And
to
maybe
operate
just
things.
circuit design could be way different.
Agreed.
Yeah, okay, fair enough. Anything else from Mr. Hendricks? Thank you, Mr. Hendricks. Mr. Pickard, welcome.
Yes. Good afternoon, Mr. Chairman, members of the committee. Thank you for the opportunity to discuss the proposal in front of you. My name's, I said my name. I represent Lumen today. We do stand in support of looking at this from a holistic view and bringing a study into play. I think we've communicated over the course of the interim with the committee in a variety of ways that there are things that should be looked at, and I think that Mr. Smolinski covered the majority of those in the list that he had proposed for the RFP. So we would stand in support of looking at all of those. As an answer to your technology question, I think it goes to one of our points about the phone bill. There are so many ways in NG 911 and currently, and to some degree, of contacting your 911 dispatch centers that are not off of twisted pair dial tone access. You can text it, you can email. There's a whole variety of things. You can messenger through your Facebook pages. And in fact, some PSAPs out there, if there is some unfortunate time that there's an outage, they provide a whole plethora of opportunities on how to communicate in an emergency situation. And so I think it's very timely to take a look at all of the aspects of the system and not just burden this on customers' telephone bills. And with that, Mr. Chairman, I'd stand for any questions.
Thank you. Questions for Mr. Pickard? Thank you, Bunch. Anybody else in the audience? Anybody else in the audience? Let's fill out the chairs. Trying to be efficient. Yes, sir. Welcome. You guys, if you want to come up from the back, or you're deliberately staying down there, I'm going to assume you're not wanting. Yes, sir. Go ahead.
Thank you, Mr. Chairman.
Is your microphone on? You have to get a green light?
Yeah, green light. I
Okay.
need to, that better?
Much
All right.
better. Thank you.
Thank you, Senator. Name's Craig Haslam. I'm retired fire chief from Fremont County, as you well know.
You're a little furrier than.
Yeah, I am a little furrier. I'm trying to be incognito a little bit, but I just wanted to come before you and the committee and thank you for the work that you're doing on this. I was actually chairman of Fremont County's dispatch center for our committee. And there's a lot of working parts that go into that. And the funding is the biggest thing, the 911 stuff, the money that comes from that. or the cell phones, all the money that comes in for that, but it is shared also by mill levies and everything else it was in Fremont County at the time when I was on the committee anyway. So, but anyway, I just wanted to thank you for your time and effort that you're putting into this and the effort that each of you are, the thoughts that are going into it. And I've sat here listening to you, and I just wanted to thank you. Sorry for taking up more time, but thank you. And I will stand for any questions that you may have for me.
Thank you. Any questions? Thank you, Mr. Haslam. Good to see you.
Good to see
You
you.
retired.
Yeah, I did.
Well, that must feel good.
I'm busier now than I've ever been in my life. It's not all it's cracked up to be.
Thank you very much. Anybody else in the room? Anybody else online?
Mr. Chairman, there's no one online.
Okay, there's no one online. Here we are, committee. We've got a bill in front of us. Sky's kind of open how we go with this. We could try to massage Mr. Smolinski's language in and make the contingencies to allow for the study and broaden the study, as well as I meant broaden the grants, have the grants and the study in the same bill. Sorry, I'm getting a little ringy. It seems like we could do that. Mr. Smolinski's language is pretty good. Needs some work, but if we adopted it and then worked on top of it, we could get through pretty quickly. It's up to you. How do you want to proceed? What's your pleasure?
Second.
Got a motion by Dockstader, second by Yen. Discussion. Would anybody like to start with Mr. Smolinski's proposed amendments? Representative Webb had his hand up. You were starting to mumble.
Thank you, Mr. Chairman. I'm wondering, because what we did with the previous, with the GOP, with the Wyoming GOP bill, where it wasn't adequately advertised, are we crossing into that same territory with
Well,
this bill?
I think the situation is a bit different in that there's been a stakeholder working group that are participating in this and have been all along. And this has kind of reached to the conclusion that some of them seem to advocate for. But that is all our interpretation. I definitely don't feel that we're crossing the line that we did before, but, the interpretation is this committee.
Can I ask a follow-up too?
Absolutely.
Okay, and it might seem a little facetious, but there is a serious point to this.
Yeah.
And that is, we've had 7 or 8, we've had representatives of 7 or 8 companies that have all supported the company, or all supported the study. Would they be willing, nobody's asked them, I'll ask them, are you willing to contribute to this study? To further benefit their company further down the road?
Certainly welcome to do that. And we could set up in the bill privately funded if you want. I'm sure they'd love that. Anybody else? Anybody else as far as which direction to go with this? Representative, I'm sorry, Landon had me first. Go ahead, Senator Landon, and then we'll go to Representative.
Mr. Chairman, I was only going to suggest, I appreciated the good senator from Goshen helping us remember that we can run a budget amendment. I think that might be better saved in our back pocket as a backup plan. I'd like to see both the amounts that we need in the bill today, if we can do it. I'm just throwing that out there, and maybe we can, when we get to that page, we can figure out how to fund both. Let's do the bridging funding. Let's get this study underway and funded both. Thank you.
Okay, this touches on Representative Senator Steinmetz, but Representative Lucas was in the queue next, and then we'll come to Steinmetz. Representative Lucas.
Thank you, Mr. Chairman. I just feel that this bill needs significant work to change it to such a degree that it goes from an implementation bill to let's fund a study, where if you look at page 2, line 9, and take that down through line, even go to 21, what we've got here is that in order to apply for the grant, then the governing body would need to have already done a study that details the equipment needed and the necessary changes to be made, whereas what we're really talking about here is a bailout and a study. We haven't even gotten to transitioning yet, but the largest part of this bill talks about transitioning and actually implementing 911. And so I just feel like this is not ready yet. And I'd really like to see this in better shape before we can commit to dollar amounts.
Thank you. I think that's a very, very fair thing. We're kind of in an emergency situation now, is kind of where this is at. So might consider it in that way. Representative Lott. Oh, I was going to do Steinmetz. I'm so sorry. Oh, I'm a little bit ringy and I apologize. I'm so sorry.
I
Sorry,
know,
Senator.
Thank you, Mr. Chairman. We all need our lunch to keep on going.
Right,
So, so there's one other thing to consider. If we put 2 appropriations in this bill, one for a study and one for an
Grants?
emergency grant,
Yeah.
the governor can line item veto this bill as well. So that's another consideration when you put the 2 appropriations in.
He can with one appropriation, can he?
I think it's 2, but anyway,
I think Josh is saying, let's get to,
Mr. Chairman, I believe it's multiple appropriations.
okay, so a single appropriation not,
a
okay.
single appropriation is, so that was one of the reasons I offered the suggestion
Fair
of
enough.
a budget footnote for the emergency funding and then just make this a straight study bill. I think that would be a lot easier to understand, get all the language about a transition out and just make it, just one paragraph that they're authorized to study and here's how much money we'll give them and that's it.
That's a very fair, probably good idea. The other way would be to have one appropriations with 2 purposes, and the governor might fight back on that. Thank you for that suggestion. Coming back this way, Representative Locke.
Thank you, Mr. Chairman. And really, my question is really just to you. You had proposed kind of Plan B or Plan C or whatever that was, where maybe a small group
Could do
worked
that.
the language. I wanted to toss that out because in my opinion, although it feels like a heavy lift, in my opinion, the study is very critical because I think we're all skeptical about you heard there's inconsistencies, there's information. I mean, when they talk about we can't get inventory, the study seems to be very important to me. And along with the fact we have this emergency issue of the other time. So that being said, I just wanted to ask you maybe for clarification on what that Plan B or C actually looks like, because that sounds like a reasonable approach. I just wanted to make sure.
Well, I guess my thinking was that if we cannot produce a bill, a few of us could band together and produce a bill. Yeah, I mean, so let's, I'm kind of, the first idea would be to try to produce a bill. And certainly Senator Steinmetz's proposal about a bill just dealing with a study and a separate budget amendment. We'd have to, what we could do, just throwing it out there, is change this to the study bill, go to lunch, and over the lunch hour, come up with the budget amendment, which would be much simpler, shorter language. And I would lean on Senator Steinmetz with her appropriations experience. You were on appropriations too. Anybody that was on, I was years ago. Yeah, Dan, I guess everybody was. Anyway, to maybe come up with, that as a possibility. To work on it over the lunch hour and come back with a budget amendment that we could approve. So Representative Yan.
Mr. Chairman, I'm supportive of the idea. I'm just a little worried about budget amendments because it ends up kind of deprioritizing
It does.
this versus everything else that will be in the budget and controversial in the budget. I would like us to have some vehicle, even if it's not perfect, moving forward. And I worry that something without the stamp of sponsorship of the committee might not have as much of a priority when it comes to our very short, quick session. So I would like to see this as a vehicle moving forward because it is necessary to handle this now and not later.
It's all fair. The appropriation as it's written and with Mr. Smolinski's changes, it has kind of 2 purposes. You might take a look at the language in section 4. So we just try to work the bill. I mean, would anybody be willing to offer Mr. Smolinski's proposed amendment?
Mr. Chairman, I would move the entire suggested language changes through an amendment,
Okay.
Mr. Spilkins.
And with the idea that we're going to further amend it, okay?
Yes.
Because otherwise it's an amendment within an amendment. It gets too goofy. So discussion? All those in favor signify by saying aye. 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 Any opposed? No. I'm getting 2 no's on the end, so I think that has carried. So the bill that we're working on right now is the bill as we received from Mr. Smolinski. It needs some more work. If you're going to deal with existing operations, I yield to Senator Steinmetz.
Thank you, Mr. Chairman. And I have an amendment to try to take care of that. I'll let Josh see how the two mesh together, if you would give me that leeway, but.
Of course.
Okay, so on page 1, line 2, delete to transition. And then delete after the next 2, delete and.
Can I interrupt you? Just
Yes, go ahead.
a slight different concept might be to do 2 things,
Okay,
which would be to say, line 2, applications for grants and a study to operate existing systems and transition to and operate next generation 911 services.
Mr. Chairman, I don't intend to let them transition
Okay.
to a study.
All right. I didn't
So,
realize that. Go
yeah,
right ahead.
Okay, all right. I just don't believe we should transition till we have a study. So this takes that completely out.
Okay.
So in line 2, delete to transition, leave the word to, delete and, leave the word operate, delete the word next. Line 3, delete generation.
Okay.
The next page, on line 3, I'll wait till y'all get there. On line 3, delete to transition to or. On line 4, delete next generation. After 911 system, put a period and delete the rest of the paragraph.
Okay.
On line 11, put a period after grants and delete the rest of the paragraph
You
because,
use the word grants like
okay,
plural.
Yeah.
It's a singular in the bill.
add an S.
Okay.
And then we had language as to what they want to study elsewhere, I believe. And then delete the rest on page 3, lines 1 through 4. And the rest of the bill should work unless it's 169113. I'm not sure what that references. I didn't look it up really quick, but I would ask for the leeway for Josh to kind of work that in if there's something I missed.
Okay, fair enough. Is there a second for the motion?
Second.
Got a second by Doc Stater. Discussion. It actually might work. Representative Webb.
Thanks, and it's been brought to my attention. In section 4, page 4, line 12, they're requesting $8 million. I haven't heard that figure today.
Oh, of his changes.
Help me out. Do that again, would you please?
Okay, on his handout, page 4.
Oh, he put 8 million. Yeah.
Yeah,
We adopted that, but remember we said the ground rules were we can further amend. So we're not stuck with 8 million if you want to change that. And obviously he took it up a notch. But that was to accomplish the 2 purposes. But it seemed like it definitely broadened the grants because he talked about price tag of $750,000 for the study. So anyway, Representative Senator Steinmetz.
Thank you, Mr. Chairman. And that was on the previous amendment. So my amendment isn't talking about money at all. I was hoping we could get back to
Yeah,
that
fair enough.
later. But if we did amend that in, I missed that too. So thank you for catching that.
Yeah, and we've got a second by Senator Dockstader. So let's deal with the amendment that she's proposed. Any further discussion on the amendment? I would give leeway for comment, but in a way, it just takes out the language, but the study, the funding is still there. So I think it actually does everything we need to do. So I think it's a good amendment. Any further discussion? All those in favor signify by saying aye. Aye. Any opposed? Okay, back on the bill. Couple of housekeeping things. For one, I don't think we can stick this. We have to have some language that allows for us to put this in Homeland Security or Department of Transportation or another agency. So we need some leeway about where this is going to go, that we're going to tighten up in the session. And Mr. Anderson, I'd look to you for some help with that. We can leave Department of Transportation and say something like, or other agency, and because well, what would you suggest?
Good question, Mr. Chairman. I don't know that I have a great solution to suggest without doing a little more thinking about it. Potentially could appropriate, because we got to appropriate the funds to, a certain entity, I think. Perhaps we appropriate to the governor or an agency designated by the governor.
I think what I'm thinking, Mr. Anderson, is that we just need loose language in the bill. And then when we work the bill in the session, by that time we'll have input from Homeland Security and see if they want it to land there. Then we can drop it right to them if that works. So I don't know if I want to do the governor's office or keep it amorphous. I'm just trying to say, I need a bill title that allows us a fishing license to maybe not be Department of Transportation.
Mr. Chairman.
Representative Yen.
So there is no specific agency language in the title. So, I mean, maybe with that ambiguity, you're still fine doing.
What do you think, Josh?
Certainly, Mr. Chairman. I think if we left it as Department of Transportation, you would have the leeway to amend that later.
But take them out and put Homeland Security?
I think so. I think that would be, I don't think that would change the bill outside its scope as introduced if you substitute one agency for another at that point. I think, we need to introduce the bill with the money going somewhere
Okay.
certain, I think.
I'll take your thinking on that. I'm like, that bill title, okay, I'll take it. So I don't think, if we go by our recommendation of our staff, it's not an issue. And then the one other thing I see is the $8 million budget creep kind of. Would anybody like to deal with that? Senator Steinmetz.
Mr. Chairman, I would say there is appropriated up to $3,750,000. I don't know what the account would be. And then bifurcate it and say, the up to 750,000 for the study and up to 3 million for budget gaps, or however we would want to word that.
Okay, I think that's good. If we look back to the bill title, we're not specifying the funding source. So if we just said general fund,
Yeah.
we could still change that during the session if we had a better space.
Yeah, or maybe even the LSRA, Mr. Chairman.
LSRA, that'd be fine. Okay,
Mr. Chairman, we have $79 million in excess we're coming into, so LSRA probably,
so you would make that as part of your motion?
yes.
Okay, so who's seconding that? Got it by Dockstader. You guys are quite the team right now. All right, discussion. All those in favor signify by saying aye. Aye. Any opposed? Anything else on the bill? Anything else on the bill? Would you call the roll on the bill?
On the motion to sponsor 26 LSO 183 911 funding as amended. Senator Boner excused. Senator Dockstetter.
Aye.
Senator Landon.
Aye.
Senator Steinmetz.
Aye.
Representative Brown.
Aye.
Representative Heft.
Aye.
Representative Johnson.
Aye.
Representative Locke.
Aye.
Representative Lucas.
No.
Representative Webb.
Aye.
Representative Weber.
No.
Representative Yin.
Aye.
Co-Chairman Knapp.
Aye.
Chairman Case.
Aye. Okay, everybody, we don't need to work on a budget amendment during the noon hour, I don't think. So all you wonderful 911 telecom folks can leave if you want. And let's come back at 2:30. That's a little bit over an hour. And Mr. Chairman will get us caught up. I know he will. Thank you. Thank you for the hard working morning.